distinction or 50 plus, or even being prize winners, all are possible. We have only 11 topics that we need to be mastering before we do a paper. There are areas which are totally compulsory that you can't enter a paper without knowing. We normally call them virgin areas simply because we haven't exhausted in terms of setting. Topics related to cooperative societies, a topic of banking, sale of goods, company, contracts, those are compulsory numbers that you can't miss out. Yeah. But then it doesn't take away the effect that other topics taught need to be just taken to be a by the way topic. No, you need to also master them. After all, they will help you in your career. If you are an employee and they want to terminate you, don't you think that you need to know your rights? Yeah. In case they give you a notice, which is way below the statutory notice, don't you think you have a right that you can claim? So there are those topics. If, for example, you have made a will or you have been entrusted with property, how do you manage? Law of trust guides you. If you're going to purchase commodities, what do you need? Sale of goods is there for you. So there are those topics that you must understand. If it is a company, some of you have shares in a company, others are directors. Yeah. But then you may find that you don't know your role as a director, as a secretary, or even an accountant. We have internal auditors. Most of you will be working under companies going to audit. What are the guidelines? But then the company's law provides for the same. So that's how law is, in a way that in the society we live in, you must be knowing these principles from the beginning. Yeah, I'm going to take you through all the 11 topics. I will also attempt at least 2 problem questions, and I give you the guide on how to answer them, as well as some objectives. Then we shall call it a day. Yeah. And what are these topics? Number 1 should be contract. No, general principles of law. Then law of contract. Agency. Partnership. Law of trust. Company law. Insolvency. Law of sale of goods. Cooperative societies. Banking and negotiable instruments. And I think last should be law of torts. Are the topics that you need to have covered before you sit your BLO paper. Whether you have read them or not, it's possible to master them from this guide and you be fit for an exam. Okay, so basically with general principles of law, which will be the first topic, I don't know whether you want it to be displayed, only that I will not write because of my handwriting. I myself, if I can't read my own handwriting, how do you expect me to write or display? Yes, I write. And still displaying will take time. So what should we do? Avoidance of doubt. Should I display? Yes? Okay, let me explore the display method, but I will not read each and everything which is on display. Well, being the first topic, general principles of law, effect number one, we need to understand what law is, because it may come as an objective. They will not ask you entire number of what is law, and they give you 20 marks. It's impossible. But per objective, it's very possible. Law being a set of rules that govern, rules and regulations that govern a particular relationship of individuals that stay within a community. In simple terms, these are a set of rules that govern particular community. Whether it is a border state, they have their own rules. Those are their laws. If it is a particular country, it has its laws. If it is a monarchy, there are some orders that maybe a king or a queen may issue. Those are the laws. So with law, every society must have some rules and regulations that govern them, which we term as law. We clear, members? Yeah. Besides that, we also need to know that we have various sources of law, where the law originates, where are those rules originating. As we earlier said, that can be a number which is set. Basically, in your number 5 or 6. Yeah, sources of law, which among others may include the Constitution. We should be all aware that the Constitution is the supreme law on land. Yeah, the Constitution is the supreme law on land. Normally comes as an objective. That the supreme law in Uganda is known as, then they bring subsidiary principle, they bring all others, but should be the Constitution. But its full name is the 1995 Constitution of Republic of Uganda as amended. Normally amended. Yeah, Tojikwatako issue amended. Of recent, we amended. So it is 1995 Constitution of Republic of Uganda as amended. That is source number one. Why? All other laws, whether contracts or employment or any other statute that you know, derive from the Constitution. It is the Constitution that mandates the Parliament to make laws. So all those laws that Parliament make must be in compliance with the Constitution. So that's why we call it a supreme law. And Section 2 is very clear that even any other law that contradicts, Article 2 of the Constitution, any other law that contradicts with the Constitution, what do they do it for? What can they do it for? Yes? If there is any law, for example, and sexuality, maybe any law, marriage act. We all know, do we have Muslims? What is the age expected for a lady to get married under Islam? Yes? 18. In Islam? 14. 14 or 16? 14. Yeah. And what does the Constitution say about marriage?
It should be above 18.
18 and above. So, in case you marry a person below that age, you think that you have committed an offense? Because in Islam, it is allowed, but then Constitution takes over. So you still need to wait until 18. That's why we say it is a supreme law. Yeah? Then for customary, men are supposed to marry when they are of what age? 30? No, it can't be 30. 21 years, customary. So do you need even to wait for 21 years? 18 is enough. So the Constitution prevails any other law. That is source number one. Number two, we have legislation. And once we deal with legislations, we are meaning acts of parliament or statutes. Any act of parliament is a source of law and is a legislation. Yeah? So you can give examples of your Contract Act, Employment Act, Trustees Incorporation Act, Cooperative Societies Act, among others. Another source of law could be common law. And as we earlier stated, common law is the law which derived from England. It comes from England by virtue of Uganda being colonized by Britain. Yeah, that's why we call it common law. Law of tort is part of common law. We never had land which was divided before the colonial era. Yeah, but by now, each person claims a portion of land. We demarcated the land because of following our master. And now, the moment you enter into somebody's land without consent or permission, it becomes trespass. Trespass is an aspect in law of tort. So common law principles are still taken to be a part of source of law simply because we adopted them from England by virtue of being colonized. Are we clear, members, on that? We have doctrines of equity as another source of law. And equity, we mean fairness. Equity means fairness. Yeah. So they are also part of the common law rules, but basically dealing with fairness. At times there is a question which was asked about it was asking about equity, basically the maxims or doctrine of equity. And I think at this stage you need to be having them, because it's also possible to examine in that area. The maxims of equity. But then we have said equity is fairness. So can I hear some of those maxims? Any person who has ever attempted to read? Yes? Maxims of equity is also supposed to be a good area of examination. Marxism stroke doctrine of equity. Doctrine stroke principles of equity. Any person who can attempt to give one or two maxims or doctrines?
Yes, I try.
Please do.
The one who comes to the equity comes with a clean hand.
That he who seeks equity must come with clean hands. That is doctrine number 1. Or it is one of them. He who comes to equity must come with clean hands. In other words, you can't seek for fairness when you yourself you're not fair. You have killed the person, but you want the other family where you killed from to compensate you. Is that possible? You have stolen, but you want the very person to whom you have stolen to compensate you. That is not possible. So he who comes to equity must come with clean hands. You find that you're going to court to urge a case, but you're forging some case laws. As let's say judge knows that a company is defined to mean a separate legal entity per Salmon versus Salmon, to you, you're saying that the name is no longer Salmon, but maybe Solomon and Salmon. So you want to confuse him so that he awards you what you need. That is not possible. So he who comes to equity must come with clean hands. Second, yes? Any other?
Equity acts in person.
Equity acts in person, or at times we call it personam. What does it mean? That if one person has wronged you, then you're not going to penalize the entire family or clan or entire country. Yeah? One has abused you, then you're only centering into his organization, that the entire organization acts contrary. Or you want damages, you're seeking compensation, but now you're claiming that you have a family, these are the, you have children who are studying and you want this. From now, the slap that they gave you, they can't compensate entire clan because of an act done to one person. So they award according to who is seeking. Equity number, maximum number 3. Yes? You have them in your notes, if I'm not mistaken. These are the ones still. Let me not even, we have equity acts in person. We have explained that. Equity acts in conscience. In other words, it acts in good faith. Yeah, acts in good faith. Equity will not suffer along without a remedy. If somebody wrongs you and you want fairness, then there is a remedy they will give. What could be that remedy? Like compensation. That's why in your exams or whenever you're writing legal issues, at the end you say whether there is any remedy available. Yeah, you can't suffer because at the end of the your write-up, you're saying that maybe there was no contract. So if there was no contract and somebody paid, what do you think he will go with? Can't he claim for the amount he paid earlier? Can't he sue? So those are the remedies. So you can't suffer a wrong without a remedy. If it follows the law, is another maxim. And that's why we are saying that where there is a written law, then fairness does not apply. I mean, where there's a written law, then you must follow that written law. What could be a good example forming part of that? If it's following the law. For example, in your contracts, under Contract Act, the law says any contract exceeding how much? Which should be in writing?
25 currents.
25 currents equivalent to
500.
500,000. So the moment you don't put it into writing, does it render the contract null and void? Yes. Does it terminate a contract in case you're going to buy commodities worth 1 million because that is exceeding 500? Then they don't write. Does it make render that contract not a valid contract? Yes or no? You're going to buy a phone, they are telling you 2 million, you have not written anywhere. They have not issued a receipt. Does it make you to have not obtained the phone legally? Yes or no? I want the answer. It does not negative that. The only way is that when you're going, in the case of any eventuality, whatever may happen at the future time, you may not claim ownership if you never had that receipt. You may not claim for damages. Because we shall ask you that the law says right. Where did you write? But then when you're using it without any effect, it's still okay. We clear members on that? Then another maxim is that equity looks at the intent rather than form. I think you will edit that word, not rather than the law, but form. F-O-R-M. Number 5. Equity looks at intent rather than the form, not law. What do we mean? We look at what you ought to have done, or we look at what is done as that which was expected to be done. What you have done as that expected to have been done for you to be awarded fairness. For example, you have signed a contract where you're supposed to render some services. You appear, students don't appear. Have you done what you're supposed to be doing? Isn't that fair? If I schedule a class, I think was it even last week, where I scheduled you people, you're the one who scheduled for a discussion. I appeared for 10 minutes without anybody turning up. I went and texted and I was like, for the low turn up, I've also excused myself. That is what ought to be done. If I found, even if it was one student, I was willing to cover up. But failure for those, then gave me a chance of doing other things. So it looks at what is the intention of what is supposed to be done. Then also equity imputes that has done to be owed to be done. They are almost similar. It looks at that which is done as supposed to be done. Another one is that equitable remedies are discretionary. I think the word discretionary, you may be aware of it. Yeah, they are awarded according to the wish of the person awarding. If they slap you and they give you 1 million, next time you can now go into a position whereby you will get 2 slaps and you expect 2 million. They will give you 2 slaps and they give you 500 shillings only. That is what discretionary means, that the one who is awarding, it's like in court. Up to now, once you go to court and you win a case, do we have a specific figure for damages? That there is a breach of a contract and now the standard figure is maybe 5 million. No, it depends. You may be suing a minister, you seek for more damages. You may be suing a normal layman person and you just seek for declarations only, orders declaring him not to do it again. So equitable remedies are discretionary. It depends on the one awarding them. He who comes to equity, I think we have covered that. That was the first point raised. Then he who seeks equity must do equity. If you're seeking for fairness, you also do fairness to yourself. Yeah? For example, what is the fairness we are meaning at this time when we say he who seeks equity must do equity? If you're beaten, domestic violence, and you fail to report the matter, you think that the authorities will know about your issue? So have you done fairness to yourself? You're complaining that there is domestic violence, but then you're not reporting a matter to the responsible authorities. Then we know they will not award you what you expect. Equity aids the vigilant, but not the indolent. Yeah, equity, that is another remedy. Equity aids the vigilant. In other words, he who is able to seek for equity if it will favor him. For example, if a person, we all know what defamation is it? Defamatory statements. Ill statements intending to lower somebody's reputation in the right thinking member of a society. So if I abuse you today and you want to report me after 10 years simply because they have made me minister for youth and maybe and children affairs, do you think you'll get that fairness? After 10 years, you bring a claim for defamation. You sign a contract today, you want to bring it after 50 years. You're not vigilant. You must work within timelines. That's what they are meaning. At least you work within what we call reasonable time. Yeah, so those are some of the equitable maxims or remedies. Remedies that you can seek for, because we have said equitable remedies are discretionary. So what are those remedies, or what are you seeking for? One is that you can go for, you can request court for an order prohibiting them, and that order we call it an order of, which order is that? Person has been trespassing, entering into your land or your house without permission. You want to go to court and prevent him from further entrance or entering. Which order are you seeking for? Yes? You're seeking for a prohibition order, coming from the word prohibiting. Prohibition order. Then somebody has taken, you made him an administrator of your estate or a trustee. That person is taking your property. Not registering them as a trustee, but now registering them in his or her personal names. Which remedy can you seek for in courts of law? Yes? Under those orders, we have injunction, specific performance, declaration, habeas corpus, restitution, tracing, mandamus, certiorari, and prohibition. Which order is favorable? Yes? An injunction. An order to prevent, to preserve the status quo. Is taking your property and you want to preserve it, that it should be taken. An injunction order, it is in two ways. We have permanent and, temporary injunctions. Yeah, but the better is, if he's taking property and you are aware that the property is at his site, you can trace them. Can't you trace the things which you know that you use? You have seen a car in his compound without consent. You can trace. He has taken your laptop and you can clearly identify it. You can trace it. Yeah? Injunction are these temporary orders maintaining a status quo. For example, if you're in court and you want declaration that court makes a finding on who is the true owner of a piece of land, yeah? But then you're the very person staying on that land. The other person claims to have bought the same piece of land for you staying on the same piece of land. And you want order to make a ruling on who is the true owner. So the first thing you can do is to seek for an injunction, maintaining the status, because you're staying there. You can just seek an injunction order to be there until the final determination. So that is maintaining the status the way it is. Whoever is on land, let him be there until we make a final ruling. That is an injunction order. Specific performance of automatically, if one party has performed his role and the other party is not performing, then you can seek for specific performance. Yeah, comparing the other party to do what he or she is supposed to do. Then restitution, compensation aimed at returning the complainant their positions as before. restitution. You may terminate a contract. For example, if you went and purchased or you ordered for a laptop, before delivery, they tell you that the car which was transporting got involved into an accident. Those are circumstances beyond each party. Can you lose your money that you had paid? You as the buyer? Can't you seek for refund? They refund you your money, then the other person bears this loss, restitution. You go to the normal position as if the contract had not happened. So those are some of the orders that you will, and those are the remedies we expect you in an exam to put. You pick one of them, don't put everything. You find that this part in a contract, this party did this, the other party never did this, then you can say under remedies, you can seek for specific performance. You can seek for a prohibition order. Since this person is trespassing, you can seek for that prohibition order, among others. Mandamus order means mandatory, compelling that person to do what he or she is supposed to do. Coming from the word mandatory, mandamus. These are Latin maxims. The statutory order means quashing the earlier decision. An example is when you're under employment, then a person terminates you over pregnancy. That you have, you're seeking for maternity leave. For how long is the maternity leave? 6 days.
3 months.
3 months.
You don't have 3 months anywhere under law of employment. Maternity leave, how long? The word is 60 working days. Must be having that working days. Yeah. Then for paternity, if you're a man, for working days, that's how equality is, fairness, doctrine of equity we have just talked about. Men, we have only 4 working days in underemployment in case your wife is delivering, or in case of a miscarriage. I think once I mentioned the word miscarriage, we know what it means. Yeah, in case of miscarriage or normal birth, 4 working days as a man. A woman, 60 working days. So in case they terminate that employee when he's still enjoying that leave, can't he go to court and they seek for an order of certiorari, quashing the decision of his employers? Can that be a remedy? The only challenge we have here are the words, how we pronounce and write them. We understand, but now in the paper we shall forget. Mandamus, certiorari, prohibition, but then that is part of law. Yeah, but then there are mandatory orders quashing the earlier decision, then they institute with the new decision. And that's what we can only do for employers who terminate unfairly. Court can make those orders quashing the earlier decision, instituting the decision they have made. So, ladies and gentlemen, are we okay with some of the remedies we can always seek for? Others are compensation also, you can add it, compensation. Because those are damages that you can seek for. I don't know whether we talked about it. No, compensation. Those are like damages, seeking for damages. Another order or another remedy you can seek for is a habeas corpus. They normally state it in objective. Habeas corpus order. By basically, habeas corpus means an order directing any person or body who has custody of another person who is expected to appear before court. So the moment you ambush a person or you keep him in your safe house or your, how is it called? Basement. You put him in your basement or in your rooftop, we expect him to appear before court and is not appearing, or in case we search for that person and we can't get him, then we can go to court, seek for an order of habeas corpus, directing that person who has custody of the person missing, produce him before courts of law. Because failure to do that automatically removes him from any crime or any act he has committed. They automatically release him because of defiance of that order. So those are some of the equitable remedies and also equitable principles that we have earlier talked about. Back to our point. So far we have mentioned 4 sources of law, but we have elaborated one, the maximum. Cost is also set. We have another source of law as custom. Yes, please. Yes. Yes, you put what? It is also okay. You normally call it accounts of profits or men's rate or men's profit. Men's profit, something like this. And what does it mean anyway? Yeah, men's profit. Basically, for example, if you have been collecting rent and you're not remitting it the actual owner, then we find that indeed you're collecting that money without authorization. You think you can go free? You will account for whatever you have collected and remit it. So that's men's profit or accounting for. Accounting for money or profit obtained. Stroke benefits. Yeah, that is one of also the remedies. Thanks for that also. Any other? And that's how the discussion should be. Contributing, we can all aid or benefit from the same. Maybe also a court order. All others are orders, but you can even make it clear that you can seek for court declarations, actually. Court declarations as one of the remedies also. Declarations. Declarations from court, as well as court orders. All those are part of remedies parties can seek. I think we know what customary law is as source of law. Those are basically the norms or practices obtained from societies that have lived for so long. The norms or rituals practiced by societies or communities that have lived for so long. For example, how the Basoga customs are totally different from the Teso, different from Baganda, different from, let's say, Bachiga, and so on. Isn't that true? And can it act as a source of growth? For example, in Angola, you can't take a beef as part of your bride price, but isn't it part of here in Uganda? Yes, tomatoes, beef, mulali, and so on. There's a tribe which they give bride price as, pigs are part of bride price. Here in Uganda, those are their customs. It's part of source of law at their site. So customs still act as source of law. Yeah, then lastly, principles of natural justice are also part of sources of law. What can we add under sources of law apart from those? Where do we get law from? In addition, you can add that we can get them from law dictionaries. Law dictionaries are source of law. An example is Black's Law Dictionary. We can also obtain law from legal philosophers or legal jurists. Yes, please. On what? Principles of natural justice and good conscience. We are meaning natural, the principles that you're born with and are not granted by any country or state. For example, under our constitution, entire chapter 4, that is from Article 20, provides for those rights which are inherent. Good example is that every person has the right to live. Yeah, a right to live. That means if one abort is against the principles of nature, we have the right to live in a clean and healthy environment. Article 39. So what happens to those people who fly Mukene full time? What happens to those who stay in Rufula? They are making you not to enjoy your rights, and therefore you can sue them for nuisance. Get my point? That there are some rights we are born with, which the state cannot grant, but we are supposed to enjoy them. And therefore they are also part of sources of law that we need to base on. And they are generally allowed, internationally allowed. That even if you leave Uganda and you go to any other country and you abuse Uganda, you have the right of living in that country that you have stayed or gone to. So those are the natural principles that we mean, and they act as source of law. Okay. Are sources of law clear to you, members? We got classifications of law, because they are also normally asked. But I think I'll be somehow faster so that we comply with time. But also, it's a matter of understanding. Faster may not be okay, but understanding the topic is crucial. Yes, classification or categories of law, I think it was part of the question they asked last sitting. Yeah, if I'm not mistaken, last sitting. And therefore, at your sitting, either classification or sources, one of them must come. Why? In examining, they look for that number that each student should be aware of. They give you those free marks, but which you must spend a pen, you must write something. And if they ask you for sources, a matter of fact, to get marks, in case they tell you 10 marks under sources, we mean you bring that point and explain it in the language you understand. Are we clear on that, members? Failure to do that, then you will give us many points so that we now mark by, we give you 1 mark each. That's the only way you can pass. Either you say constitution and you say in Uganda, the constitution is known as 1995, Constitution of Republic of, they can give you 2 marks. You have mentioned the constitution, you have even given it, or you have said it is a supreme law. If you say customs, indicate that every tribe has its own customs and they act as source of law in their areas. You get your 2 marks. So you bring that point and in your own words, how you appreciate it. Failure for that, then you're going to say constitution, customary law, common law, doctrines of equity, law dictionaries, legal jurists. You will give us a list of 20. Give you 1 mark and you get your 12 marks. So that's how law is marked. You either bring a principle and how you appreciate it, or you bring many, so that we mark what, at least we double the marks by giving you 1. So it is better you appreciate it with a point or you elaborate it. Classifications or sources of, classifications or categories of law is also a good area of examination under general principles of law. How law is categorized. We have it in almost 6 aspects or 7. We have the public law, that go vis-a-vis with what? With private. Yeah. Classifications. How can you classify? For example, if you want to know whether you are teaching students, you may say these are the boys, then these are the girls. That is the classification you're making. Then on average, boys maybe participate more than girls, or girls participate more than boys. Same applies to this classification. That you must say public law, then on opposite side, you bring the opposite of that public, which is private. In case you say criminal, the opposite side should be civil. The moment you say public international law, the other side should be private international law. The moment you say procedure law, this other side you need to be saying substantive
law.
That's how we classify them. That point clear, members? Yeah, but then basically let us go through them briefly. Public law, that is automatically the law that governs all the citizens as well as the state organs. The law that will govern all the citizens and state organs. What can be a good example of a public law that governs all the state organs as well as citizens? I've just mentioned it as a supreme law. What can be that law? Yes? The Constitution is a good example of a public law because even a president gets his mandate or powers from the Constitution. The Parliament, before it makes laws, it gets its powers from the Constitution. So it is a good example of a public law. It is a branch of law regulating citizens as well as the state and also the organs of the state. Whereas private law, that branch of law which deals with the rights and obligations. Never you mention private and you fail to put the word rights and obligations. We clear, members, on that? Because
Yes,
with private, it means individual arrangements. But then what are they arranging? Their rights and obligations. What one has aimed to do and vis-a-vis his obligation to perform. Civil law compared to criminal law, with civil law, what are we dealing with? We are regulating now the rights and obligations. Yeah. With private, we are dealing with the law, basically mentioning what are the rights and what are the obligations. But now to regulate those rights and obligations, we need civil law. I think online students, you're following. So the law that regulates is civil, but the law that basically defines is private. Same applies to criminal. Criminal law is that kind of law which will define things that every citizen must do or must not do. For example, penal code will tell you, in case of an offense with these ingredients, makes it maybe murder, rape, and so on. So that is a criminal part of law. It is a law which will define what things that a citizen must do or must not do, and it will give or award a punishment to the wrongdoers. Substantive law, basically for it, is a body of rules which specify what is lawful and what is unlawful. The substantive law in this case, we mean like Contract Act. It will tell you that a contract is defined under Section 10 to mean ABCD. So it is telling you what it amounts to. It is a substance. Whereas the procedure are the steps you can follow while applying that substance. So the procedure law are like the steps to be followed. For example, if you made a contract and you define the terms, those terms must comply with the substantive law. But now the procedure to follow Whether you want to go to court because of a breach, whether you want to call a middle person whom we call like mediator, come and intervene, it becomes now the process. Or how we can attain that award is the process. So that is the procedural law. We have public international law vis-a-vis private. Most students confuse those two now. A public international law, we mean that law that head of states or their agents sign with different countries. The law where head of states or their agents sign with different states. Good example could be, is Uganda part of UN convention? Yes or no? Are we under East African Community something treaty? So where our head of state, for example, president or minister, signs a law that all other neighboring countries, all the countries that have paid signature on that document will follow, becomes the public international law. Are we bound by homosexuality? Because there are some countries that endorse homosexuality act, actually approving that homosexuality should occur. Is Uganda part of it? So we are not part of that public international law. But then private international law, we mean individuals in different states signing a contract together. It doesn't necessarily need your country to have signed with the other country. But you as individuals, you can make your own arrangement and sign. Does Uganda have has it ever signed a law with, let's say, Russia? Yes? Oh, we don't know.
Not sure.
We are not sure. Which countries at least we know that even they may not be sounding and Uganda may not have signed any contract with them? Yes? What are those some of the countries that, for example, Chad, I think is a country also. Do we know any law that Uganda has ever signed with Chad? But what if an individual of Chad wants to transact with a Ugandan citizen and they make arrangements? Don't you think that they can be governed by some law and that law can be private law? So in that private law, what are they aiming at? They can put the courts they will use. They are the ones to determine the courts. They are the ones to determine the currency to use because we may not be having a specific currency to be using. They may determine the terms in their contract. They may determine at what stage can be a breach, among others. So if an individual of country A signs with an individual of country B, the contract they have becomes private international because they are from different countries. We get the difference between public and private international laws. Customary law, I don't think I will need to explain. The law that emanates from the norms and customs of a generally accepted society. Yeah, and we have those customs. I remember studying with Pygmies, if you have ever heard of them. And they have the good society, eating what? Honey. Love that kind of food. So that's their custom. They use not to. I think they have now changed, but by then, they used not stay in houses. You go under the tree, that is it all. That is their shelter. You produce children, children produce others under the tree. Yes, I can testify by then, 2003. So those are the customs of Pygmies. I will not engage more in what they did. The moment we could go for church service and a drum, those people could run knowing that there is now a war outbreak. But then that was their custom. Okay, they may ask you differences between common case law and common law. That is also a good area of concentration, maybe. But it all begins with knowing what case law is. The case law is part of sources of law. I don't know whether we mentioned it. Please write it somewhere. Case law as sources of law. So a case law basically is that law emanating from the decisions of judicial officers or quasi-judicial officers. I think once I mentioned the word quasi, then we know. Officers who are almost in that category. The AG, the labor officers are part of quasi-judicial. The tribunals, don't we have like tax, is it called tax appeal tribunal? Where do you remit your taxes? So you don't pay taxes. So failure to pay, what do they do? Which tribunal do you go to? Or you're just waiting to complete, then you get that server job. Anyhow, so the case law are these laws emanating from the decisions of judicial officers or quasi-judicial people who are acting in that capacity like judicial officers. Their decisions are known as judgments, but then they form what we call case law. Whereas common law, as we earlier stated, are the laws coming from England but are applicable here in Uganda by virtue of colonization. So let us go through the advantages of case law. Number one, certainty. Case law ensures consistency in rules and law, thus contributing certainty. In other words, we all know that once the decision is made, before it is changed, it makes an impact. Good example is when we are defining like a company. We have those famous cases, salmon versus salmon, air farming versus who? Yes, you are forgetting those cases. Makaura versus who? Anyway, but certainty we mean if there is a principle made, or the doctrine made, or a decision taken, then it can be there for some good time unless changed by still another judicial office of a higher rank. Then growth, case laws help in the need of, they deal with changes in needs of society by providing approach the problem, the practical problems. Yeah, growth. For example, we all know that if it is like marriage, there are some things we need to consider, whether it is customary marriage or civil or any other, they deal with those practical problems. Domestic violence, we have some decided cases. Good example could be division of property upon dissolution of marriage. How much does a man take or a woman take in case of dissolution? They take 50-50. That's the decision you have. Or they don't take any, they leave it. But we have decided cases, that's why I'm bringing that. Yeah, we have the case of Dr. Not a doctor, I think. I've just forgotten the clear party. Yeah, Himbi Somewhere Hope versus Julius Rabinumi. They explained how much each party can take in terms of dissolution of marriage. And therefore, we can always base on that. Even if you want to also dissolve your marriage, you're going to court and you're referring that case. In Julius Rabinumi versus Hope in Somewhere, they define that any property acquired before marriage doesn't form part of marriage property. Any property acquired during marriage forms part of marriage property. Any property acquired after divorce, but when when divorce is not made absolute, also doesn't form part of the matrimonial property. That is the principle in that case. So we can always refer to that. That's why we say that it can deal with practical problems. Then detailed. There's a case I have ever read which had 1,000 pages. It was URA versing something. So they are always detailed. They will give you what, how, for example, this case of who read the judgment of Narukola and that lady who was under the election petition, Nambi Farida. And the person who took a keen eye to read through the judgment, it was a 65-page judgment. The case of Dr. Kiza Vestige, not Kiza Vestige, the one who petitioned and removed court martials, trying civilians. Kabaziguruka something, Honorable Kabaziguruka. The judgment was over in 200 pages, only judgment. So they are always detailed. That's the advantage, that you can read and appreciate why they have gone through that. But disadvantages, the moment it's detailed, it becomes bulk to read. Imagine you're only compiling it and you're going to show the judicial officer that this is a case I'm relying on. Itself challenges your documents you're presenting. Yeah? Rigidity. Rigidity, we mean that a decision which was earlier taken, we are still following it. Why can't we make changes? Because society has evolved. A decision which was made without technology is the same decision we are basing on, even when we have technology. So that becomes a disadvantage because of rigidity. Yeah. Then also, its advantage is that it makes judges become less in terms of reasoning. Instead of making his own decision, he wants to rely on that decision which was earlier taken. We don't refer you to that case. Yet he has the ability of determining his own. Those are some of the disadvantages of case law. We can talk about delegated legislation briefly, and we are meaning that the parliament has power to do what? To pass laws or enact laws. However, where it may not pass the laws, it can give authority to other agencies to do it on its behalf, and we call it delegated legislation. Yeah? We clear on that, members? Parliament, under the constitution provisions, has powers to make laws or to pass bills, hence becoming laws. However, where it may not make laws and signs another entity to make laws on its behalf, it becomes delegated legislation. So we want to know the reasons why the parliament may do such. Why is it assigning yet is its primary duty? Number one, it saves time. For example, whenever it gave mandate to Bank of Uganda to make regulations basically on financial institutions, but then it saves time. Bank of Uganda, being experts, know how they can handle monetary related issues. Yeah, so it is one way where instead of taking only dropout, senior 6 dropout who qualifies to make those laws relating to financial related aspects, you better sign an entity which is an expert in dealing. Number two, agency. Whenever it assigns duties to other agencies like local government, then the laws which are passed help in that agency situation, other than sitting to pass the bill which may take so long. Then technicality of the subject matter. Basically, the parliament as a general body or parliamentarians may not be experts in some areas. Therefore, referring a matter to qualified personnel helps in saving time. Flexibility, parliament being rigid with inflexible procedures makes it easier if it awards an institution to make laws on its behalf because it is flexible. So that is under delegated legislation. Mark that word because it may come as just a number with 2 marks. Delegated legislation itself. Yeah, but basically it means where parliament assigns any other entity to make laws on its behalf. Lastly, allow me to talk about courts. They are also examinable. And under courts, we need to know that in Uganda, judiciary is the body that interprets the law. But then the courts of law are enshrined in the constitution. They are provided for in the constitution from Article 126 and onwards. So we need to see what are these courts and their jurisdictions or their powers. The highest court on record is known as the Supreme Court. That's the topmost court, the Supreme Court. Followed by which court? Court of Appeal, also sitting as a constitutional court. Because they normally ask that, and they give you that free mark in your objectives. A court that sits as a constitutional court is, then they bring other courts. You need to select Court of Appeal. Then after Court of Appeal, what court is below? High Court. After High Court, Chief Magistrate. Then after Chief Magistrate, Magistrate Grade 1, and lastly, Magistrate
grade 2.
We don't have court martial under our court. A court martial is a mere administrative tribunal or court. Just like the way we have children and family courts, we don't mention them here. Yeah, the LC1 court, they are not mentioned, but they are court. Same applies to court martial. So let us see basically the key features of each. So for chief magistrate, for magistrate grade 2, actually there are these two confusing words, and I need clarity from you. So they are normally asked. If they ask you for courts of record, and courts of judicature, which courts are you going to mention here? How many are the courts of record? 3. What are those 3 courts? Supreme, Court of Appeal, Constitutional Court, and High Court. Please mark it. If they request for courts of record, the word record limits them. Why are they for record? They can try any matter. They are not limited. That's make them to be courts of record. They can pass the highest sentence and makes them to be on record. Whereas courts of judicature, they expect you to start from Supreme Court up to the lowest court. So you bring all of them. We clear on that, members?
Yes, sir.
Okay, so let us go through each court briefly. If it is Court of Magistrate Grade 2, and also they normally ask on the, just I think P1 English, the sequence. What is the highest score? I mean, from the highest, the lowest, from the lowest, the highest, from, descending order, ascending order. You need to be just knowing those by terminology. Ascending means?
From up
Ascending is
downward.
from top to down. That is ascending.
Yes.
Then descending?
From bottom upwards.
Starting to doubt whether people have been playing for Easter period. In Easter, it's when we believe what Jesus did what? Ascended. He never descended, but he ascended. So you mean he was from top to down in ascending? Please mark them. Ascending, we are meaning from the lowest to the highest. Descending from the highest to the lowest. Okay, magistrate grade 2. Then magistrate grade 1. I want you to tell me the key features of each. Then chief. then High Court, Court of Appeal, Constitutional, Court of Appeal, Constitutional Court, and then Supreme Court. Civil and criminal. So what are the key features, or how can you identify these courts? What are their powers dealing with civil and criminal? Magistrate grade 2 in civil matters, yes, doesn't exceed 5 million. Doesn't try a matter exceeding 5 million. In criminal matters, what sentence can it give? Can be life, not exceeding 3 years. We clear on that, members? In civil matters, magistrate grade 2 don't exceed 5 million. So if you have a contract which is exceeding 5 million, chief magistrate grade 2 does not try it. Then in criminal matters, it tries matters which don't exceed 3 years. In other words, it tries what we call misdemeanors. Then for grade 2, grade 1, civil matters. Yes?
It handles cases to 20 million.
30.
20.
Not exceeding 20 million. Then in criminal matters, grade 1, sentence of not exceeding how many years?
5 years.
Are we doing guesswork? Yet we are in the final touches. A punishment. Not attracting life, imprisonment. A punishment not attracting life, imprisonment. Then chief. Yes, for chief. In terms of monetary value, not exceeding how much? Not exceeding
50 million.
50 million.
Then for punishments,
Life can give life imprisonment, but not death.
not attracting a death penalty or sentence. Yeah, whether death penalty or sentence. So any matter that does not attract a death sentence can be tried. Then High Court.
Unlimited jurisdiction.
It has what we call unlimited jurisdiction. In other words, even if it is 100 shillings you can go there. They have stolen your pen. You can file, go to High Court, and they give you an award. That's unlimited jurisdiction. Even if it is $1 billion, you can go. Then whereas criminal, yes, it awards maximum sentence of death. So it has power to award even death sentence. Then Court of Appeal, what is the key feature of it?
It can hear appeals from High Court.
Very good. Also, maybe before Court of Appeal, High Court, we can also indicate that it can attain appeals from the lower court. Yeah, it can attain appeals from the lower courts. Also, Chief Magistrate can only attain appeals from grade 2. A Chief Magistrate can attain appeals from grade 2. It can't attain a grade 1 appeal. Doesn't have power. Grade 1, you go to High Court direct. Also, when you're satisfied with a Chief Magistrate decision, you go to High Court. Yeah, then for High Court, can attain any appeal from those lower courts. Then Court of Appeal can attain an appeal from High Court. So if you're satisfied with the decision of High Court, you can go to Court of Appeal. And second unique feature is that Court of Appeal can sit as which court? As a constitutional court, while interpreting the Constitution. Then Supreme Court, what is the key feature of it? A unique feature that it has.
It handles constitutional appeals.
I'm going to answer, I have noted your question. Let me first complete this. Here it can attain what we call presidential petitions for the first time. This one can interpret Constitution. Yeah. So then also any appeal from the Court of Appeal, you can go to Supreme Court. Yeah. So it has two unique features. Then also in awarding criminal sentences, they can all award maximum of death penalty. Yes, there's a question that I had from the other side. What's wrong with Court of Appeal? Oh, the criminal side is that they can all, from High Court and above, they can attain matters of up to the death sentence or death penalty. We are done with courts members, unless otherwise. And I think the last part I can deal with, interpretation of the law. Interpretation. What are the rules governing interpretation that you know? Yes? Rules of interpretation. Normally comes in the objective. Interpretation of statutes or gross stroke statutes. Number one, literal rule. Number two, golden rule, mischief rule. Yes, another one. Pardon? A positive. A positive approach. The next.
Mischief rule.
Mischief we have it.
Okay. Mm,
Edudem generis rule. Any other? Yes? As part of rules of interpretation. Maybe legal dictionaries, that one can be okay. Any other? So briefly, with literal, what do they mean? Words to be given their plain meaning, their ordinary meaning. If the word is bottle, then they mean bottle. Yeah, depending on the framers of the act, but every word must be given its plain or ordinary meaning. So that is the rule that we apply in most cases. So once you go to court, in most cases when people make wills, a dummy, you find that there are some words which are indicated and they are always in need of an interpretation. So we use those ordinary meanings. Some of the people who write wills in local language, they use those complicated terminologies. So any interpreter should give that terminology the ordinary meaning, and through that we mean a literal rule. Same applies to acts of parliament. If they say currency, we need to know what a currency is in its ordinary meaning. Then we have a golden rule. What is it about? Yes, if you're interpreting the act or a statute and you find that they want to apply a golden rule. Yes? Is there as part B, the bold letter? Golden rule is to be read in conjunction with the literal rule. So you read the term, applying also its ordinary sense, in the ordinary grammatic sense, yeah, of the words used in a statute to adhere to the rules, so that you don't come up with absurdity or repugnancy of the rest of the law. So as you want to make some change, ensure that the word should also be read together with the ordinary meaning, so that you don't create confusion of this entire sentence. Because you may need to make some change, but how have you interpreted it? First, give it the ordinary meaning. If it can't fit, then whatever change you may create should be still in line of not changing too much in terms of the meaning of the intended writer. That is the golden. Mischief, we are basically meaning that you may use the most useful of the rules. In other words, not come up with a long or a mischief that is causing law or a statute to be enacted. Yeah? They are giving you an example that in that case of Smith versus Hoggs in 1960, the prostitution and solicitation that was conducted on streets, there were some prostitutes who were conducting soliciting effect and also calling for customers. Yeah, in 1960, so that habit has not begun here in Uganda. It used to be in England also. So the law which was passed was to prohibit any prostitute who could call clients or customers. And they had to remove them from streets. They even imposed the punishment that whoever was on the street and soliciting for a client, then he was more likely to suffer a penalty. So what these prostitutes did, they started now going into a building and they go on the topmost floors. They are not stepping on the street, but they are still on the street buildings on upper floors. So when they were dragged to court, the question was whether the law meant to remain on street or even part of a building was under the law. And of course, the court indicated that to apply a mischief rule is not to come up with the wrong intentions of the drafter. So if they prohibited people on streets even going on the buildings next to the street and you go the different floors, we are still in contravene of the same law. So that's how a mischief applies, that you look for the intention so that you don't come up with the wrong decision. A purposive comes from the word purpose. What is the aim of the person who is interpreting? Purposive approach, coming from the word purpose, means that as you're interpreting the law, you must put into consideration the purpose to which that law was enacted. Yeah. Etutem genes rule means words of the same kind. So in case you face words of the same kind, how can you go about them? So it is one of the ways of interpreting the law that you can, if words are used, but then they mean the same or they are under the same category, you can look for the most appropriate, or you can select one word at least. Because there are some people who write 10 words meaning the same. The way you used to write your love letters when you're still in high school. Yeah. Dictionaries are part of the ways how we can interpret the law. Yeah, we can apply legal dictionaries. I've given you an example, Blackstone Dictionary. Legal texts also help in interpreting the law, as well as the treaties or the laws which are signed. Ladies and gentlemen, topic number 1 is done. Other topics I may be rushing, or even I may not display. It will depend. But if there's any question, I can attain it. Do we have any? Expect 17% of your objectives come from what we have discussed. And you can also expect some number on part 5 or number 5 or 6 to also emanate from what we have discussed. So it cuts across on objectives as well as the direct numbers. Proof contract, what do we need to know? Number 1, we need to know what a contract is. Number 2, we need to know ways of entering into a contract. We need to elaborate on each element of a contract. We need to know what is and how a contract can come to an end, I think. Maybe the terms of a contract also. Terms of a contract, fundamental terms of a contract. I will not write, but I will be maybe rushing somehow because of time. The contract is defined under section 10 of your contract. Currently, it is section 9. Section 9 of your Contracts Act, which cap number? Of contract. Law applicable is the Contracts Act, cap 284. Some of you are still quoting Contracts Act of 2010. You're in the ancient era. So you need to know the definition of a contract. And that is per section 9(1) of the same act. The only advantage is that once you appreciate the definition, then you have known all the elements. You have known halfway of what is expected to be dealt with in your work. The moment you appreciate the elements of a contract, gives you a chance. I mean, the definition of what a contract is gives you a chance to know all the elements in a contract. And what is a contract? Yes, please. You may be given up, we may deduct a mark of going for old laws, yet we have a new law. Yeah. At least you better, instead of putting 2010, better say Contracts Act and you stop from there. Are we clear, members? If you don't trust the CAP number we mean a chapter number. Just put that, Contracts Act, Companies Act, Employment Act. Yeah, don't put the numbers. The moment you put a number which is wrong, it is also a wrong mark because you're quoting wrong rows. At least leave it in space. Just say an act. This act, partnership act. What is the number of a partnership? Yes, what is the CAP number? 100 and what? 110. Partnership Act 110. Companies Act, CAP what? 10106. Employment Act, CAP number what? 200 and what? 220, 26. If you don't know them, please refrain from quoting them. Sale of Goods and Supply of Services Act, CAP number what? Cooperative Society, CAP number what? So you better leave them. Just stop on the word Act. Cooperative Societies Act. Companies Act. Contract Act. You can be on the safe side. At the moment you start putting your years, because they formerly had years, but effective 1st of July last year, the laws changed. So that's why we adopt the new laws. Okay, the definition gives you almost 50% of what you need to know in the contracts. And therefore, what is the definition of a contract? Yes? A contract is I'm writing, so whoever is reading. I know it, but I want the simplest definition of how you understood, not reading. A legally binding? Yes? Between parties? That is it. Who have capacity? For consideration? I'm writing what you're giving me, not what is from my head. Only that. So I even put a full stop. Okay. You can take it in that way, or you can as well say a contract is an agreement made with free consent of the parties who have capacity for a lawful consideration is intention of making it legally binding. Within this definition, you have captured everything. The moment you say a contract is an agreement, does any person agree alone? And is there an agreement? Are all agreements contracts? Are all agreements contracts? Yes or no? If we agree to go to the church, is that a contract? Why? We agree to go to the church and pray. We go for service, a mass. Is that an agreement? Is that a contract? What is missing? So not all agreements are contracts, but all contracts are agreements. So you need to be mastering that a contract is an agreement. That's agreement number one, because you cannot agree alone, and therefore even that agreement, to make it a contract, there is also something to consider. So number two, that must be with free. What does this word mean? Free consent. It now brings a factor that once it is entered without free consent, then vitiating factors come in. Mistake, misrepresentation, fraud, duress, and due influence. All those come once there is no free consent. So you must be free, willing. They are meaning willingness. Another element is about parties. What does parties mean? Weddings and also birthdays. We don't mean weddings. We mean people. Parties are people or persons. And we have two categories of persons. What and what? Natural and artificial. So what is an example of an artificial person? Companies, because they also contract. The natural are we, the people who live or who breathe, who do what, any other person. So parties we are meaning the natural or artificial, but basically we are meaning person. And the person in law is either a natural person or an artificial person. So that is also an element that you're going to consider. Then having capacity is another element. Capacity, they mean what? Yes? Two? Ability two is capacity. So under capacity, what can we consider?
Age.
Age? Which age? If you're 90, you can't contract.
18 years and above.
18 and above. Apart from age, capacity-wise, what do we consider?
Mental capacity.
Mental.
With a sound mind.
Mental capacity, stroke sound, mind. What else? The last element.
Competence.
Not prohibited by any. Competence means capacity generally. But once you say not prohibited by any law, we mean either if he's a natural person is not under bankruptcy. And if it is a company is not under insolvency or liquidation. Then age, as we say that for one to make a contract, he must be of 18 and above. Do we have exceptions?
Yeah.
What are the exceptions where you can be either below 18 and you make a contract?
Education and necessities.
One, necessity. Two, education. Three, employment services. All these were defined in the case of Nash versus Inaman. Where they brought these elements. And the next time they pick one of them. That is the worst. They'll bring you scenarios to know that indeed, however much this person was below 18, he was contracting for a necessity. However much this person was below 18, he was contracting for education. services. All together, members? So capacity-wise, know that even a person who is below 18 can make a contract. But on circumstances like a necessity we mean something which is suitable in the life of a minor at a time of entering into a contract. Something which is suitable. If he's going to school, what are the suitable things? Scholastic materials. If it is a wedding party, maybe for his parents, what are those scholastic, the necessities? A dress code maybe may matter. This minor can go to the tailor and get a clean cloth. You get a point. If they are in sports gala, what are necessities? The sports wear from shoes and onwards. You don't expect at the day of, let's say, how are they called, where they evaluate the competency, to be a day when this child is buying now sportswear. You make the point. So necessity depends on the suitability in terms of the needs of a minor at a time of entering into a contract. So we look at that time of entering into a contract. Education, every minor can contract provided is excelling in education career. If you think that a contract he or she is entering into is for academic purposes or education, he or she can. Employment, here there is a condition. For employment, the work must be light and not hazardous on his or her health. Work is not, which is not hazardous on his or her health. It's rare to find a minor contracting to work in a stone quarry. But haven't we seen Felicitas and fresh kids signing contracts to sing? So in the moment they deem feel that is not hazardous to their life, the law allows them to sign the contract. Mental capacity, we have also things we need to consider. Under mental capacity, what are we considering? Because the law says you must be of sound mind or mentally okay. What are the exceptions to mental capacity? Yes? If a person is, you cannot contract. So they are saying that if one is permanently suffering from a mental disability, he cannot contract. Of course, that one comes with a report of who? Psychiatric. Yeah, but that is not an exception. I want an exception. Where a person may be suffering from a mental state, but still makes the contract which is valid. Yes? When you're suffering from temporary state of mind, don't we have them? The lunatics? Or, you normally use it as an abuse, yet is an English word, idiots. The moment his capacity is not permanently insane, then in his periodical arrangements, he can only contract when he's okay. We have them. These Abagube Daru. During rainy season, they are okay. Sunny season, they are totally off. So you target him in the rainy season, you even take him, he signs the contract of selling his piece of land to you. Then you wait for the sunny season to go into, you'll be paying him in installment. When he's off, you wait to pay because he has no capacity of contracting. When you think that he has gained conscious, then you again sign. So if you're suffering from a temporary state of mind, he can contract. Yeah. Number two, some of you are in this state now.
If a person is too drunk,
Yes. You, the drunkards, you also have no capacity of contracting. The only exception is when you understand the nature of the contract you're entering into. Are we okay on that, members? Drunkards don't have capacity of contracting because they are not in the sober state. They are not in their mental well state. But the moment they understand the nature of the contract they are entering into, then they can contract. So the moment you start saying another order, we know that your mental state is still working. Another round, we know that your mental state is still, not until we carry you when you can't even hold yourself. At that stage, you can't also say another order. So drunkards can also contract however much their mental state is not okay at the moment when they are drunk. And now, it depends. There are those who even take half than even a bottle and they are off. There are some of you who are experts. You take a crate and also order for the next. So the moment for us to recognize whether you are in your mental state is when you understand the nature of the contract you entered into. Not prohibited by law, we mean that a person who is under bankruptcy cannot contract. And also, a company which is under liquidation cannot contract. Members, are we okay with the element of capacity? Lawful consideration. That is another element in contract. What do we consider here? Yes? What is consideration? What is consideration?
Price value.
Consideration is price value. Pardon? Is the what? Monetary value.
The benefit received.
Benefit received. Don't we have a legal terminology of what consideration is? These are all correct, but we have the most appropriate. What is in your books? Because I expect one tell me consideration and you bring even the parties. Yes? What is consideration, members?
It's a benefit received by a party who gives a promise to perform or act.
Benefit received by a party who makes a promise. What are those parties? Don't they have specific names? In consideration, we have the offer and the offeree. They are not. Promiser and the promisee, those are the parties. So consideration must be that monetary value agreed upon by the parties in a contract, who are the promiser and the promisee. Yes, so let us talk about, they normally ask about rules governing offers. But before rules governing offers, types of consideration. How many are they? There are two. One, executed consideration and executory consideration. What is the difference between the same? Executed consideration is also known as past consideration, and it is not enforceable. Executed consideration is known as the past consideration and not enforceable. Good example is, as we are here in class, you find a maid at home has taken your cows or the cattle for grazing and is demanding you 50,000. Since the herdsman went for a leave to watchman you, will you pay for that 50,000 the maid? Yes or no? Will you pay? You have not made arrangement with the maid. You find that she has performed the work and is now expecting consideration. Will you pay that money? Why? Yes? For you can do so. Because you never made a promise. You never made a promise. You never promised that once you take them, I will pay you this. So if you never made a promise, then you're not bound by her promise upon doing the activity. So we consider that as a past consideration and which is not paid for. It is not valid. Then executory consideration is known as a present or future consideration. Future consideration. Is it paid for? The answer is yes, because once you agree that I will pay you today, you're bound. The moment you say that I will be paying in installments, that means may occur in the future time, you will still be bound. So it makes it a valid consideration. But past consideration is not a consideration. Rules governing considerations. Be keen, it may also be part of your exams. Rules governing and I hear some of them. One, pardon?
Consideration must be an
It must not be past. Next,
must be illegal.
must be legal. Next,
Must move from
Must not be past.
then must not be adequate.
Not be
Adequate.
must not be past.
I think we have it. The one of past is number one. Next, next,
Should be required for any simple contract.
we have it. Is it all?
Yeah.
among others. So those are some of the rules that govern consideration. It must not be past. You can even now add the other one that we talked about, can be of future or present. Is also a rule. Yeah. It must be legal. In other words, which the law recognizes. It must move with a promise. One party must have promised something, then the other party. It's like one losing something and one gaining it. That is the promise we are making, and that's the consideration. You're losing money, but getting services. The other person is losing his efforts to earn that money. Yeah, it must be adequate, not adequate, but sufficient. We don't need to pay you exactly what you expect, but something which is reasonable. All simple contracts require consideration. It must be in legal tender. Legal tender, we mean currencies. Even if they pay you using a check, they are paid you in case they pay using cash or any other. Okay. Do you have any other element we left behind? Lawful consideration, intention of making it legally binding, that is self-explanatory as an element of a contract. Your intentions in a contract must be recognized under the law. Yeah. For example, can you sell Lake Victoria? Can you sell CPS Kampala? State House, you said it. You sell entire Mount Rensol, is it yours? Do you own it? So those are the things we talk about in terms of legally binding. You can't sell Mavila. After all, it is not yours. Yeah, so you're doing illegal act. Okay, leaving that aside, we can also as well talk about rules governing what? Governing offers. What is an offer? Yes? A willingness of expression in a contract. That is an offer. Willingness of expression. Who are the parties of the offer?
Offer and offerees.
Offer and offeree.
Offeree and offerer.
Offer.
So what are these rules that govern offers? You have known the parties that one is the offerer offering something. Then another one is an offeree receiving that offer. Yeah. You have also known that an offer itself is a willingness of expression in a contract. So want to know what are the rules governing offers? Pardon?
An offer must be communicated to the offeree. Must be communicated to the offeree.
Must be communicated to the offeree. Yeah, you can't give an offer and you don't communicate. For example, whoever gets, let's say you have lost your bag and you're saying whoever picks your bag should be paid this amount or should be offered that amount. You must communicate it. Two,
Must come from offerer to offeree.
next. Yes? cannot be revoked after acceptance. Then even that one creates even another element. What is that element now?
It can elapse.
They elapse upon specified period or reasonable period. Next. It must be accepted. The next, any other? Yes? These are some of the rules that you need to be aware of. That an offer must be communicated. They must be certain. Yes, there's another one.
Can one say that an offer must be clear? Or it's the same as
certain or clear.
communicated?
It's okay. And say it must be certain, show clear. That one is okay. Yes, please. That is still okay. The mode of acceptance, you can indicate it, whether the one you have indicated or within how the parties have agreed. There's another one actually missing about counter offers. Is the rule there? What is that rule? Counter offer does what?
First was the initial one. First was the initial one.
Counter offer terminates initial offer. These are some of the rules. You must communicate it. It must come from the offerer to the offeree. It cannot be revoked upon acceptance. So the moment they accept it, you can't change your mind. Yeah. They elapse upon specified period or reasonable period. They must be accepted, must be clear. Counter offer terminates the initial offer. They will bring you some set of facts. For example, they say A lost a bag. He communicated in the local radios that whoever picks his bag is willing to offer 1 million or is willing to give him 1 million. B picked the bag but never heard of the announcement. Upon checking the documents, he delivered the bag to A. A declined to pay B the promised offer. B is seeking advice from you. What are you going to advise? Do I need to repeat those facts? A lost a bag, including his documents. He made announcements that whoever could pick the bag was supposed to be given 1 million cash. B picked the bag. He communicated the same on the radio channels or stations. B picked the bag, but never had the announcement. He delivered the bag to A. A never paid that 1 million. B is before you seeking for advice. How are you going to advise B? Is he entitled to 1 million?
Yes.
Yes, no.
Yes.
I've said B never had that announcement, but he delivered. Is he entitled?
Yes, he's entitled.
Did he accept? Yes? Did he accept? Haven't we said that one of the rules governing offer is number 4? Offer must be accepted. Did he accept the offer of 1 million? By virtue of not hearing the announcement, did he accept?
No.
Yes. You know, withdrawal is funny. The moment you put in the normal feelings, you go with wrong answers. He can't gain anything. You're going to advise him that since offer must be communicated and accepted, and the fact that they communicated the offer, yet be never heard of that offer, it meant that he never accepted the offer he never heard of. Therefore, is not entitled to 1 million. You get your 5 marks. First thing on the word that offer must be accepted. You can't accept what you have not heard of. Now, what if they asked him how much do you need? Could he still claim for 1 million? Because he never had the announcement. So you can't claim for what you don't know. Yeah, so offer must be accepted. So there you are on advising B that is not entitled to anything since the communication of acceptance, since he never accepted the offer indicated. As simple as that.
Excuse me, sir.
Yes, please.
There is a scenario that in one of the questions says party A told party B he had land, that one time I would sell this land at 5 million. That is party A. Upon some period of elapsing, party B got 5 million and told party A that I want the other land you told me. And party B said, no, I'm not going to sell it to you. In this scenario, we saw they communicated and this one refused to accept the offer. What advice could one give?
Have we all had a comment saying that there is a question which was said indicating that the offer was communicated in terms of land. One wanted to buy land, they even agreed. However, he never paid land and some period passed by. After, when he got money and took the money to the person who was selling, the other person declined to receive. Yeah, they are now, and yet they had agreed. So he's asking, which remedy can you give? What rule there can apply? Rule number 4, what does it say?
Not be revoked after acceptance.
Yes? They elapse upon specified period. So if I give you an offer and you go home and sleep, you wait for your salary, I have an urgent issue. Do you think that I will be bound by your money once you bring it? So the way you have said, after you have said that he took time, but he never returned in reasonable period. So that offer had elapsed upon reasonable period.
Oh,
Yeah.
okay.
So yes, that rule of period, time frame is key. Okay, let us leave
Thank you.
offers. Okay, welcome. Another thing you need to know in contracts, maybe formation of a contract. Yeah, yet complete contracts, formation of contracts. How can a contract be entered into? Yes. 4 ways. 1, written. 2, oral. 3, this is that funny person making a funny noise. Written, oral. 3,
Slide.
party written and party oral. That's 3. Yes. Implied by conduct of parties. That is the formation of the contract. You may summarize them indicating that contracts can be written, can be formed by express or implied. That is the summary. Written contracts, we said anything exceeding how much? Must be in writing. Then oral contracts, any simple contract, any contract less than that amount is advisable even if you don't write. Party written or party oral, we mean that some contracts can be written, but then they leave provisions of oral aspects. For example, in your employment contracts, don't you have provisions that you will be entitled to benefits? Do they indicate which benefits? They indicate and specific amount for those benefits? Yes or no? If they say airtime, they even specify which airtime. If they say that insurance, they specify the percentage. So you can even calculate and know the exact amount. But there are some contracts which they will tell you that you're entitled to some employment benefits, but they don't express them. E.g., when you're in a camp, do they specify how much they will give you when they send you for assignment in a camp, accommodation and so on, and food? Yes? Yes. Do they specify the amount? So that is part of the contract that you have a written contract, but those provisions go for oral now. That's why we say that some contracts are partly written and partly oral, because they may just indicate that you're entitled to benefits, but they don't specify which benefits and which amount. Yeah, then implied by conduct of parties, we mean how parties behave. The moment you meet a person in Airtel T-shirt, do you think that is working with KFC? Automatically is for Airtel services. That is implied. You meet one with, will not say political parties, after all, they don't enter two contracts. Yes, but also, if, for example, you take your car for washing, you pay, the next day you don't pay, the next day you pay, you take like 5 times without paying, those people can sue you for an implied, for a breach of a contract, yet you never signed the contract. Why? Implication of your conduct, that you have been paying, at times not paying, but now this time you have adamantly paid to pay. So that's the implication of parties. Of parties, and that is under express. Leaving that aside, let us look at fundamental terms of a contract. How many are they? How can we define these two fundamental terms? What is the condition?
Is the major term of a contract.
They are saying a condition is a major term of a contract. Once it is breached, it terminates the entire contract. Yeah. A condition is a major term of a contract, breach of which terminates a contract or renders the contract as if it never happened. Whereas the warranty, a minor term of a contract, breach of which Which of which does what? Entitles the innocent party some remedies. So you need to master those two. For example, if you're buying a car and the only challenge you have on that car is that the seats are in white color, yet you want them in red because you support no. But the same vehicle you ordered for, can you terminate the contract? So that one amounts to a warrant. It is minor. They can even buy for you seat covers of red, and you go when you're happy. You're buying a calculator, the only thing you're basing on is that the color of the calculator. Yeah, there are so some, you're buying a TV set, your only worry is about the batteries of remote. That you can't take a TV set because batteries are now Toshiba, yet you need the other long-serving batteries. Those are minor. So they amount to warrants. But the condition could be if you're buying, let's say, an HP laptop, they give you a Dell laptop. You want a smart TV, they give you a analog TV set. Are we clear, members, on the condition and warrants?
Yes.
Okay, one terminates the contract automatically, another one does not terminate but can award the innocent party damages. What else have we left behind in the contract?
Vitiating factors.
Okay, vitiating factor. Maybe when we talked about also offers, we never talked about ways how those offers can be terminated. We need to talk about them. Termination of offers.
Yeah.
Briefly, you can write them maybe. One, termination of an offer, elapse of time. Two, acceptance. Three, revocation before acceptance. Four, death of any party, death of an offerer or offeree before acceptance. Next, insanity of any party before acceptance. The next, illegalities. Yeah, you can't give an offer which is illegal. At the moment you kill A, B, C, D, I'm giving you the entire house. That offer is illegal. Have you captured them? Yes? Vitiating factors in a contract. Vitiating factors. And you had earlier mentioned them, so I think they will not be easier. One. Yes? Judas.
Right.
Cloud. Undue influence.
Misrepresentation.
Misrepresentation.
Yeah.
Mistake.
Mistake.
Any other? Illegalities.
Impossible. Yeah, illegality.
What is Judas? Use of force or exerted pleasure. Use of force or violence to make one enter into a contract. Yeah, for example, a wife holding a panga for a man to sign on a land agreement. Yes? Wife cannot do. Don't you have mafias who are wives? A man holding a gun, enticing a wife to sign. Is that enticement under a gun? So they amount to undue duress, and therefore one party who was placed under that force can sign a contract, but then later change his mind and say, I signed under this influence, and that contract can be terminated there and then. It's a matter of going to court and say, yes, I signed, but I was under this influence. Yes? Evidence. Yeah, you can bring evidence if you have. You can even carry that very panga. You can even bring the eyewitness who were present. You can have a recording, any form of, pardon? Circumstances. If you can't have those, you prove the circumstances. This man wanted to pay loan. I rejected. He placed me under the gunpoint. I signed. If you check on the records of bank, yeah, they indicate the period which we signed this contract, referring the very period when he took the amount. You get the point? So those instances, you can make them corroborative evidence. They can all prove your point. Fraud, I mean, fraud. What is a fraud? Yes?
It's just intentional.
Is what?
A fraud is where somebody
Disconnect us.
A dishonest?
Act.
A dishonest act. It was defined in the case of Frederick Zabwe versus Orient Bank. Yeah, they brought elements of fraud, what fraud is. Dishonest act. You may enter into a contract, but in a dishonest manner. Yeah? For example, one telling you that this is, you sign here to the ticket, giving you, maybe giving you a visa or what, yet you're signing for withdrawal your account in your money is in the bank. Yeah? The intentions, he has ill intentions and is making you sign a contract when you have not fully understood the nature of the contract. Or you're signing for a land agreement, you know that it is only 1 million, the person is saying that you're going to pay 1 billion. Can you still be bound by that agreement? When you know that you're going to pay 1 million, the very person who drafted indicated many zeros to make it a billion. Can you say that I'm still supposed to be paying that 1 billion? You raise an influence of fraud, a dishonest act that the only way the contract I signed was for 1 million, not a billion shilling. Then you have an undue influence, use of what? Yes? Use of exerted pressure. From who? From a person with control or authority during a contract. Over you anyway, over another person. Yeah, what could be an example of an undue influence? You go to the church, they tell you that nobody is living without a partner. You start now seeing whether you can get one. Yeah, you find that the one you want even has no eyes but has specs. Others who are okay, they have already taken them. But then the rule is nobody is moving without. So we say that the pastor was using that undue influence. Yeah, it must arise where there is a relationship of e.g. master servant, pastor, pastor and what? Pastor and sheep. The way you could term it. We normally call them followers. Yeah, pastor and followers, not sheep. employer, employee, principal, and agent, all those are part of the undue factors that can bring undue influence. Misrepresentation. False statements made by one party inducing another party to enter into a contract. False statements. Misrepresentation are false statements made by one party towards another party, inducing him to enter into a contract. Good example, I also suffered one of it. Went to buy shoes, they told me that I had a memory card. Moment I purchased, if I go near the church, gospel music will start. If I go to the party, secular music will now take over. That even when I'm reading, I can even be hearing the voice of my lecturers. So I purchased that shoe. Only to find out a soul with only wood at a high expense. So that is part of misrepresentation. False statements made to another party, inducing him to enter into a contract. So I returned the shoe and they had to give me a refund. Mistake. What is a mistake? Yes, what is a mistake? Erroneous belief of fact. Error. Tokola error. Erroneous belief of fact. That is a mistake. A mistake is an erroneous belief of fact. As you believe, for example, you can be mistaken. You see the person moving, you think that is a man, yet is not, and you enter into a marriage contract. Those errors happen. You think that you're contracting with an accountant, yet he has paid bill for 5 years. You think that you're dealing with a lawyer, yet is the Mufelewe Chibuga. Mistake. Yeah, so those are erroneous belief of facts. However, we have types of mistakes. And we normally ask on these types of mistakes. One, common mistake, unilateral mistake. Yes. Mutual. Next. Mistake of fact. Mistake of law. Mistake of what? Yeah, quality. Next. So what is a common mistake? And what is the effect of it? A common mistake. This is where parties to a contract can, they are mistaken on the subject matter. Whereas you believe that you're contracting for, let's say for purchase of laptop, and whereas you believe that the laptop do exist at your electronic shop, the shop has been caught by fire. So you may conclude the contract, yet the subject matter does not exist. It becomes a common mistake. At that time of entering, you knew that the subject matter existed, whereas it was not existing. So it renders the contract void from the beginning. Are we clear on that? Unilateral mistake. One party is aware of a mistake, another party is not aware of that mistake. If you know that the figures are 1 million, the other party hasn't observed that. Then for you, say, you sign, don't worry, sign. I will deliver the same, you just sign. So it becomes a unilateral mistake, and therefore, can that contract go ahead? Is it enforceable? It's enforceable at the option of the innocent party. So you can decide either to go with it or terminate it. Mutual mistake. All parties to the contract are at advanced possession or advanced ideas. Whereas you know that you're contracting for a vehicle, the other party is knowing that is contracting for tuk-tuk. You're all making a contract, same contract, and you're willing to pay for the vehicle. So it becomes a mutual mistake and also renders also the same mistake. It renders the contract void. Mistake of facts, the same, rendering the contract void. Mistake of law, rendering the contract void. Mistake of quality, whereas you know that you have bought cotton clothing, even the other person, whereas knows that they have sold you cotton, you find that they are not cotton. Comes mistake of quality. Therefore, it is voidable. Any party can void it. I think we have exhausted those. Then lastly, illegality. We all know what illegality is. If you're below the law, then legalities render the contract what? A nullity from the beginning. We need to know but we have already discussed them. Effects of this contract. What is a void contract? Voidable, voidable, illegal, and what? Valid and enforceable. A void contract is the contract which does what? Yes? That elements of a valid contract from the beginning. Voidable, it is a valid contract but enforceable by innocent party. Illegal contract, contracts not contracts which under the law are what? Are not recognized. A valid contract, it has all a valid contract has all elements of the contract. Unenforceable, the contracts which under the law cannot be enforced. What is an example of an enforceable contract? Yes? E.g. entering a contract with a person who doesn't have capacity to enter into a contract. It comes hard for you to enforce it. Okay, void, obviously, from the beginning, they don't have any valid element. Maybe there was no agreement. If there was an agreement, the parties had no capacity. If they had capacity, no consideration. So any element missing makes the contract void. Voidable is always valid, but one party can enforce it, e.g. a contract and a mistake. Illegal, Contracts which under the law are prohibited, e.g. sale of cocaine, sale of marijuana, among others. Unenforceable, they can be valid but not enforced. Okay. Anything we have left? Yeah, discharge of a contract. How contracts come to an end. Discharge stroke termination. Can I get those answers? How can a contract come to an end? Performance, where parties perform their obligations and rights, contract comes to an end. 2, frustrations. These are what? What are frustrations? Yes?
Circumstance happens which makes the performance of a contract not to happen.
Beyond control of parties. Yeah? And there are many. They normally ask each actually have observed in the last 4 sittings, they bring an element under frustration. They need to be keen. And how do they bring it? Just say that there was a contract, maybe before execution, fire broke out and damaged the property. So if a person can know that fire is part of frustration, can't give that answer. They tell you that they made a contract, but the war broke out. Can you still perform your obligations under the law, under the war?
No.
They still bring facts indicating that COVID-19 hindered the performance, but the other party leads the other person to perform. Isn't it a pandemic? So let us give maybe examples that fall under frustrations. War outbreak. Next. Yes. Earthquake. Those natural calamities. Let me just say natural calamities. Must be knowing them at this stage. Natural calamities. Fire outbreak. What else? Accident. Any other? So under natural calamities, you have very many factors. Earthquake, thunder, floods, drought. Maybe you are supplying crops, but because of drought, you can no longer. Yeah, so you need to be very, very keen. At least see what is hindering the parties. If it is beyond their control, just say that under this, it was affected by frustration, and therefore it terminated the contract. Okay, element number 3 of a discharge of a contract. Breach. Breach of what? What else can hinder a contract come to an end? Yes? Agreement. Yeah, parties can agree. We have performed what we have performed, let us conclude. Next, a notice of termination. One party can notify the other if he is no longer interested. Next. Yes? Can court order terminate a contract? Any other? Pardon? Specific performance as well of terminating a contract. Oh, period, yes, time elapsed. Yeah, time elapse can end a contract. If for some of you are where you're working from, don't you have a contract specifying time? Or your contract indicates mpaka last over May. If you're under the government, even don't they sign contracts which expire? Don't they renew? So even age limit, okay, statutory or age limit can also be part of it. Age limit, stroke statutory periods. Any other? I think these are self-explanatory. Any point that you need clarity on under those? On what? Breach of, okay, breach of terms of a contract. You can say breach of terms or obligations of parties. I think I need to give you a break or we can proceed. We are done with contracts.
Small,
Yes? Do we need a break right now or we can first proceed? How many minutes?
10.
10. Okay, because I don't want you people to doze. But then also be preparing questions. Yeah, past papers, if you have that you face a challenge, we can interpret it together. So let us be back by 44 minutes past midday. All right, students. Any confirmation whether you can hear me?
Loud and clear.
We can hear you.
Yes, we are back from the break. The break turned to be lunch by virtue of time. Let us quickly go through partnerships. I don't think we have much to deal with it. Number one, we need to know the law applicable under partnership, being a partnership act. Capword 110. That's the law applicable. Few things to note under partnership. One, we must appreciate the definition. Yeah, and that is per section 2, subsection 1, where the partnership is defined to mean a business done in common between parties not exceeding 20 with a common objective of making profits. Also, by virtue of this definition, it helps you to understand basically more things in a partnership. It's okay, you can enter with your food. Whoever is eating is admitted to enter. So that is the definition of what a partnership is: a business done in common between parties or between two or more parties, not exceeding 20, with an aim of making profits. The key elements here we are looking at, because the facts may come when you need to know which kind of business. For you to know that it's a partnership, automatically it must be a business done in common. In other words, if parties agree to deal in shoes, selling of shoes, then you can't expect one party to be selling vehicles. They all agree whether to be in shoes. If they want to add, they cannot agree that they are going to be selling shoes and vehicles in that manner. You can't find one party selling agricultural products, another party selling charcoal, another one selling vehicles, and you say that that is a partnership. Unless if it is in the objectives that they are dealing in all of those at the same time. Yeah. Then number two is that the number 2 to 20. And lastly, intention. Intention is making profit. The moment a partnership starts making losses or advances in making losses, it is one of the grounds of dissolving a partnership. Yeah, the moment, if they began with 1 million, at the end of the year, they are now indebted 20 million, then it ceases to be a partnership. It must be with an intention of making profit. Yeah, so once you appreciate the definition, you need to, because objectives may come with some numbers dealing with the types of partners. Can I get some of them? What are some of the partners? A dormant partner. At times we call them sleeping partners. Why are they sleeping or dormant? They are not actively involved in the day-to-day running of the business. Yeah. So the second type, yes?
Active partner.
General. As partners, what is the type of partnership?
You also
Holding
have
out
active.
partners. Yes, there is online students giving us an answer.
You have active partner.
Active partners. Active stroke managing partners. Any other? Yes?
You have quasi.
Limited liability partners. That all? So you need to be aware of this, because any can do an activity which can help. Pardon? I've added it there. Active managing stroke general. Yeah, they mean the same. Acting, stroke managing, stroke general, partners. They are involved in day-to-day running of partnership. They are the one responsible in day-to-day running of a partnership. Whereas the dormant partner is not actively involved in the business. Holding out partners are partners on specific occasions or specific tasks. They only operate under specific tasks. Then limited liability partners are partners under what we call a limited liability partnership. So the moment you register a limited liability partnership, partners who are supposed to be there are limited liability partners. However, the law says under a limited liability partnership, there must be one partner who is unlimited, or what we call a general partner. I repeat, we have these three types of partnerships. Actually, let me even write them here. Now, types of partnerships. We have been looking at types of partners, but now these are types of partnerships. One, we have the general partnership. We have professional partnership, and we have limited liability partnership. Under general partnerships, we are basically meaning a partnership which is formed informally, not written, not registered. You can either decide to make it verbal, you may write, and you just have a partnership agreement, what we normally call a partnership deed. You may not register it with a registrar of documents at URSB. So that's the general partnership. Just like the way you can agree. Now today being, let's say, Matters Day, let us just venture in selling Matters clothing. Then you buy, you contribute capital, you buy. You make one who has not contributed sell for you. Or you directly involved in that kind of business. That is a general partnership. The law says they should be at least 2, but not exceeding 20. There's a time when they ask that question that A, B, C are partners. They have been operating a partnership for the last 2 years. However, they have realized profits, and A, one of the partners, has requested the rest, in brackets B and C, to bring each 6 partners so that the business can develop. C and D are confused and seeking for your advice. What are you going to advise in that circumstance? This is a business. They have been operating it for the last 2 years. There have been 3. One of them brings an idea that each brings 6. The other 2 haven't appreciated the idea. They are seeking for your advice. What are you going to advise? Yes? What is the logic behind that? They're exceeding the number by how many? So they are 21. Can that still be a partnership? Because they have not told you that it is dealing in a particular field to make it a professional partnership. They have not told you that they registered it as a limited, to make it a limited. So in other words, in absence of specifying, it remains the general partnership. So you're going to advise that that business cannot operate. It becomes illegal since the partnership does not exceed 20 members. That's the only logic. The only advice you're giving these people is that they should not buy that idea because a partnership doesn't exceed 20 members. Professional partnerships, they must be in particular, they must be having a particular profession, either accountants, doctors, lawyers, engineers, any profession that you know of. They form it, they don't need to exceed 50. But then doesn't mean that if they are below 50, they don't form it. No, not exceeding. 51 is not allowed, but below 50 is allowed. But also you can't form a partnership when you are alone. Must be two, up to that number they have limited to. A limited liability partnership doesn't exceed 100. If you read section 47 of your Partnership Act, it limits a limited liability partnership to 100 members. However, it says that there must be one partner who is with what? There must be one partner whose liability is unlimited, making him a general partner. Yes, there must, in a limited liability partnership, all partners are limited apart from one who becomes an unlimited partner, and thereafter he runs all the activities. Are we clear on that, members? Okay, then from that, I think we shall need to know the properties that form partnership or that don't form partnership. Not properties, elements that don't form a partnership. What are those? Yes? What are the things that cannot happen in a partnership? Or if you're in a partnership, you cannot try them. They are like three. Under Section 3 of your Partnership Act. Pardon? Involving in the same business does not form partnership. Who can read Section 3 of the Partnership Act? ME8, download it. Things of gross, sharing of gross profits are the things I expect.
One can be a debt or a loan. It cannot form a partnership.
A debt or a loan?
Yes.
Yeah, we have just talked about section 47 about what? What did we say about section 47? A type of a partnership known as a limited liability partnership. But section 3, I think, basically section 3. Yeah, rules for determining existence of a partnership. Rules that they determine, things that you must consider before you set up a partnership. Determining whether a partnership does or does not exist, regard shall be had on the following. 1, joint tenancy, tenancy in common, joint property, common property, or part of ownership does not create a partnership. So you put that as element number 1. A joint property or tenancy in common does not. Simple explanation. If I own an item with my wife, yeah, we have a piece of land. Then I decide to join a partnership, but then our names are registered on that land title. Then in a partnership, they request for each partner to give a piece of land. Can I put that land title where my wife is a has legal interest? Is a joint property. I personally don't have any property in my individual name, but the partnership requests for each partner to give a plot of land. Can I surrender that land title? Why? Reason being, the wife is not a partner. So I cannot give something which we own jointly, giving it on behalf of my side. So a joint property cannot. Tenancy in common, they mean having a plot of land, maybe one plot of land, but 10 people can know their percentage, their portion in that property. You can't also give it to be part of the partnership. Because it's one piece of land, but each knowing where he or she ends. So that can't also create. Number 2, sharing of gross returns does not itself create a partnership. Gross returns. What is the gross return? Members, what is the gross return? Anybody doing quantitative techniques? QT? Or mathematics or entrepreneurship? I personally never studied math. But it's like another, even I think it was Nikon and entrepreneur. What is the gross return?
It's models of profits.
The gross profits. They don't form part of it. Why? They first deduct expenses. So the moment if, for example, you all contributed 1 million and your 3 partners, that means those are 3 million. You venture in buying, let's say, cars. At the end of the month, you find that your entire amount you have obtained in that month is 20 million. Can you share those 20 million? Yes or no? You all contributed 1 million towards the common objective of buying vehicles. You bought and sold them. You have achieved the wholesome amount of 20 million. Can you indicate that as being things that can form a partnership? No. Why? You first deduct what you initially invested in. Deduct all the expenses that accrue, then you share the profits. So you don't share the entire amount. Do you get my point, members? You deduct what you incurred. Whoever was transporting first pay him. Don't calculate him on that 20 million. Maybe the other expenses like buying of books, records, and what, put them aside. Buying calculators, put them aside because you are calculating. Then whatever could be that fixed figure of interest, even if they are only 5 million, that's what you can share, not sharing the entire gross of 20 millions. So entire gross amount or gross return does not form part of partnership. But once you deduct all expenses, then whatever is remaining can form part of a partnership. Lastly, the receipt of a person of a share of a profit of a business is a prima facie evidence that he or she is a partner in a business, but the receipt of a share or payment contingent on varying of the profits of business does not itself make a person a partner in business. And they are giving you other aspects. The word prima facie means on the face of it. Yeah, so they are telling you that receiving the receipt by a person of a share of profits in a business is not evident that you're a partner. The moment you share on some losses, some profits, doesn't make you a partner. Yeah, unless they are giving exceptions. If you have paid for those things and you have shared with them, then it can make you a partner. If they make some profits and they just give you, award you, don't qualify to be in those big boys or partners. Okay, but basically those three, sharing of gross returns does not form partnership. Joint property does not form partnership, does not form part of the forming of partnership. And also receiving of the interest. Then partnership need to be registered, specifically professional and limited liability partnership. It is a must. Register them. General, you don't need to, but the other two, it is a must. Yeah. Powers of a partnership, they need to be having a partnership deed. You can have an agreement and register it. It acts as like your objectives. What you need also to know more in terms of partnerships. Yes, please. Circumstances that do what? Yes. Sharing of expenses. Yeah, it does not cause personal expenses. You don't. They don't form part. For example, if I've incurred money, let's say this is a partnership. An example of this class being we are all partners. Yeah. Then we have contributed on buying of seeds and so on. To me, I turn on duty, I don't find the rim. I buy it using my personal cash, not the expense of the farm. Whatever we may obtain, you first deduct for what I incurred. So those expenses, you first deduct personal expenses that arise in carrying out the business. Yeah, so the moment they are just still gross expenses, they don't. You get my point, members? Liability of partners, you need to know it because it is mostly examinable. Liability of partners, as provided for under Section 9. What you need to know, number one, is that all partners are jointly and severally liable towards the debts and obligations in a partnership. That point very clear? All of the word joint and several is like you're all together, and at the same moment, you're all liable as partners. Whether it is about profits, whether it is about debts or obligations. Number two, where a partner dies, what becomes the liability? His or her estate is severally liable to due cost of administration of debts and obligations of the firm as far as it remains unsatisfied. What do we mean? If you're a partner and you die, yet the firm is still demanded, you go ahead and sell your assets to cover up that debt. That is the second liability. The first one is all partners are liable jointly and severally. Number two, in case of death of a partner, as they suggest on how to pay, they can also consider the estate of that departed partner, that partner who died. So his estate should also be captured too. They sell it off and clear part of the debt. Third is that where you're declared bankrupt, what happens? Yes, please. Yes. And I trust. Very good question. What happens where you die as a partner, yet you had placed all your property under a trust? Who can answer that? Simple answer to that. A trust can be defeated if it was created less than 12 months. The moment you create it and 12 months have not elapsed, then the intention is that you wanted to defeat the people who are demanding you. So it can be cancelled, then the amount paid. They can cancel that trust created within 12, actually not 12 months, 2 years. It's limited to 2 years. The moment you create it, we first establish whether it falls within 2 years. If it is within 2 years, they cancel that trust. If it is above 2 years, they don't cancel it. The only remedy there which you have is to go and they declare that person a bankrupt person. Yes, please. The moment they go for your personal assets is when they have certified themselves that the assets in a partnership have failed to certify that debt. So they can opt for your personal assets now. Yes, but they first give the first remedy on the assets. Yeah, another liability is that when the estate of a partner who dies or becomes bankrupt, or of a partner who is not having or have been not having knowledge, dealing with the firm, to be a partner retires from the firm, is not liable to the debts. I think we have sung this for many times. Ongoing and outgoing partners, liability of those ongoing and incoming and outgoing partners. The effect is if you're incoming, you're not liable to the debts that incurred before your joining of a partnership. Even you, the outgoing, you're not liable to anything that happened after your departure. So you're only liable to what happened during the era when you're a partner. That is the liability also. Minors, are they liable in a partnership? Yes or no? Minors are liable to share profits only, but not liable to losses. Yes, please. the creditors when you were still a partner, not after. Yes, even if you depart from a partnership and they are still demanding it, you will be liable from the era you joined up the date you departed. That habit still goes on. Even if it is after 5 years and one brings the receipt, if the date falls on that era where you are still a partner, you're liable. The same applies to the sharing of profits. If there is any money generated that falls under that period, you're liable to the proceeds of it. So it is both on the liability term and also on the debt term. Then minors have said minors are liable to only profits in a partnership, not losses. The exception is a partner will be liable to, will not be liable to losses if that partner quits or leaves the partnership before attaining the age of 18 years. The moment you encroach 18 at midnight, they can look for you and you pay for whatever happened when you were still a minor. Because you have now capacity, you can contract. Under the law, you are an old person. So that is the trick of minors. They can be there, share profits. A night before 18, they can give a notice and quit. That one, they will not be liable to any losses that incurred when you are minors. Yeah, but the moment you encroach 18, even if you joined when you were 2 years, we shall sum up and you add interest for any debt that incurred. That is under section 10. Okay, then liability of minor partner on attaining the majority age, I think I've explained that. The moment you attain 18, you're liable to both profits and losses and also the losses that incurred when you're a minor. You're still liable to them. Liability of the firm, if you do an activity as partners, then it affects the firm. You all entire partners are liable. Yes. However, where a partner enters into a contract without permission of other partners, he can't be liable. The firm can't be liable. Holding out partners, if you hold out, in other words, if you express yourself to be a partner yet you're not, can a firm be affected? You're not a partner, you're claiming that I'm from Amis Enterprise. We deal with training, trenches, and so on, yet you're not. Can your boss, your firm, be liable? The firm cannot be liable if you're holding out on your personal capacity. Yeah. However, if the firm gives you consent to go and hold out on its behalf, then it is automatically liable. I think we have also talked about a bit of incoming and outgoing partners. Yeah, then the next thing you need to know is about duties of these partners. Duties of partners in a partnership. What are those some of the duties? Do they have some duties as partners? Can they enter contracts on behalf of the firm? Can they act as agents? Pardon? So in partnership, basically, then at what stage does a partnership come to an end? When can a partnership be terminated? Elapse of time. Can death of a partner terminate a partnership? The answer is no. Death of a partner does not terminate a partnership. Exception is yes, if it is provided for in the partnership deed or agreement. So death is not an automatic way of terminating a partnership. Court order can terminate a partnership. Perpetual losses, concurrent losses, where a partnership deals in losses, it ends the partnership. What else? Are they the only ways how a partnership can come to an end? Can you notice terminate a partnership? Yes? So you need to be knowing those, at least those few, that a partnership can come to an end, one, where there is provisions of a partnership deed, e.g., if it gives death as a reason. Two, insanity of a partner. Insanity of a partner can lead to termination of a partnership if they go to court and seek for court order. Yeah. Three, specific time. If the partnership is designated for specific time and that time encroaches, can also make it. But then fulfillment of the task. You can be partners in a specific task. The moment you complete them, come to an end. Have we talked about rights of partners? All partners are entitled to equal shares of capital and profits in a partnership, and also as well as losses. The firm can indemnify a partner in the case of his personal expenses. Indemnification, compensating you. The moment you're a partner and you use your personal money for running a partnership business, other partners can compensate you. Then also, each partner may take part of, has a duty of managing a partnership. No partner can introduce a partner without the consent of others. Majority partners cannot expel a partner. Those are some of the rights of partners. As we earlier said, partners act as agents and they can sign contracts. Their duties, every partner needs to give accountability and also the duty of competition. Those two they normally ask on them. Competition and accountability. Where does competition come from? They may bring facts, e.g., A and B have a partnership firm known as AB firm. Their firm deals in taking of photographs and videography. One day, B, upon accumulating all his assets gained from the farm, decided to buy another camera and gave it to Mr. Z. Always take photographs on the functions where the farm is involved. It came to a notice of B that this habit of taking photos by Mr. Z acting on behalf of B has occurred for the last 3 months. Mr. A partner, is unhappy with the actions of B and seeks your advice. What are you going to advise? One partner bought camera and gave it to a colleague, always come and take photos where the farm is involved, in absentia of the other party, knowing. So this party, upon knowing, is now before you seeking for advice. What are you going to advise? Yes, is in breach of which duty? Accountability or competition? A partner doesn't need to compete with a partnership. So buying a camera yet in the business of a firm dealing in photographies is part of competition. Then accountability, the moment they find you liable for competition, they will even make you to give every detail of the amount collected. You make that accountability and give it to the firm. That's what the law says. Accountability. Every partner is bound to render full accounts and true accounts of everything affecting the partnership. Every partner must account for any benefit deriving without the consent of the other partners. Okay, liability, we have talked about them, how they are liable. I won't repeat. Maybe lastly could be how a partnership comes to an end. By court, by agreement, when a partner becomes lunatic or insane, where they are acting in illegal business, because they may start with legal, they end up in illegal. It's very possible. You start selling the dodos and so on, the greens. From greens, now you adapt to the alien skins greens. You start selling them. So it becomes illegal. Yeah, you start selling meat, you start up a butcher. At the end of the day, you involve now human beings' meat. Whoever gets involved in an accident, you now take it to the butcher. So those are illegal activities and can render a partnership come to an end. And where it runs on the losses, yeah. That is it basically with partnerships. There's nothing much. Point of emphasis, know the rights of partners, know the types of partnerships, know the dissolution of a partnership, how it comes to an end. And it's a definition itself. It will be good to do any number during this partnership. And also those two duties, the duty of accountability and the duty not to compete with the partnership. Law of agency, under agency, we are going to see that which law is applicable under agency? Yes? You have shifted to another topic. Agency now. Which law is applicable? Contracts Act. Because agency is under topic 10 of your Contracts Act, or chapter 10, or part 10, because they are written in Arabic X. So agents, what do you need to know under agents? To know when is an agency relationship created? An agency relationship is created when what? Because there are like 4 aspects you need to appreciate under agency. Just like 4. It is a contractual obligation where the principal authorizes another person known as an agent to transact with which people? With third parties. Simple as that. A contract existing where a principal authorizes an agent to deal with third parties. Once you appreciate that, you automatically know that the ways of entering into an agency relationship are the same ways of formation of a contract. We talked about them. There are 4. 1, formation of an agency is same as formation of a contract. Written, oral, party written, and implied by conduct. They are the same ways. Anything what you need to appreciate under agency are the parties. Who are the parties? principal, agent, and third parties, because an agent can't work alone. Yeah. Then creation of an agency relationship, we have already talked about them. But in addition of the other four, you can still add these two. In addition of written, oral, partly written and partly oral and implied by conduct, you can as well add ratification. Ratification. And what is ratification? A process where the principal admits or approves the action of an agent. Yeah, a process under which the principal approves the acts of an agent, of course, which are done within reasonable time. That is one. Then the second is necessity. And what is necessity? A relationship created by genuine emergency to protect principal's goods. That situation that a principal needs protect the goods, the agent needs to do it, protect the goods of principal becomes the necessity. Then the last is what? Cohabitation. So you must have cohabitation, ratification, necessity, written, oral, implied. There's a year when they asked ways of creating an agency by operation of law. Students never wrote. Yet, whether they say that creation of an agency, another one says creation of an agency by operation of law, they mean the same. So the word operation of law, they thought maybe things have changed. So be keen. Cohabitation, we are meaning where people are living together like a husband and wife, then one party authorizes another to act on his behalf. Yeah, but there are instances where the other party who authorized may change his mind. For example, if that party authorized or left you with sufficient allowance, you cannot pay for other goods that you obtained under that cohabitation. If they are excessive in nature, he bought you a green dress, he bought you a red dress, you also want NRM dress, or you want NUP dress or PFF, cannot buy. If you want the shopkeeper not supply you with the goods of the same commodity, then for you, the shopkeeper gives. Can that person be liable to pay? Yet you want the shopkeeper? Obviously no. Also, if you want the very person, his partner or her partner, not to obtain goods on credit, and that person goes ahead to get goods on credit, can that person be liable? Obviously still no. So he can only be liable to goods bought under necessity. Yeah, so and so I appreciate those. Where they normally ask about the rights and duties of agents and principals. As an agent, these are some of the rights. Number one, you need to be observing lawful instructions of your principal and due diligence, rendering full accountability, acting in good faith, and also not making profits beyond the commission. Those are some of the duties. They normally ask them. Also keeping information confidential. Yet with the duties of principal, there are few. One, they are like three. He has a duty, because the other one has a duty to work as an agent, he has a duty to work. That means as a principal, you have a duty to pay for the work done. As an agent has a duty to work for a commission, this other person has a duty to indemnify in case of amount exceeding what is ordered for. Indemnification. Then in case of suing, if they sue the agent, you as the principal, you have that duty of going to defend your agent because he's acting on behalf of you. Lastly, ways how an agency relationship can come to an end. Termination also. Almost each topic goes with termination. We talked about termination of contract, talked about termination of partnership. We are now in termination of agents. And one of the ways of terminating an agency relationship, performance. Just the same way in contract, you just copy and paste. Performance, death of any party. Yeah, because even an agent, even if a principal dies or even an agent, relationship comes to an end. A fixed period, if you sign somebody to act for like 2 years and they expire. Insanity of who? Yes? Principal or agent? Yes? Principals, all of them or any of them. Because the moment you become insane, you don't have capacity of entering into a contract. So even the relationship you had as a legal relationship comes to an end. Then bankruptcy of the principal, as well as frustration. Frustration, we say those are the unforeseeable circumstances. And also dealing in illegality. If your boss is making you to be an agent of dealing in illegality, you remember Sober Act. A man who was called, is it Sober or Sobi? Sobi. What he was dealing in, totally illegal. And he was saying that he was an agent acting on behalf of some government officials. So that one also should terminate a contract here and there. Types of agents, whether they ask you types or categories, they mean the same. Types and categories under agents mean the same. Can I hear some of them? Brokers, auctioneers, bankers, Dale Credale, patent agents, insurance, solicitors, stockbrokers, among others. Which one is that I need to explain in those? A Dale Credale agent. Yes? With brokers. The basic difference is that these brokers, most cases, can have a specific task. It could be estate brokers, and therefore their brokerage is in terms of land. They could be insurance brokers dealing in shipping or goods that come overseas. Yeah, so they have a specific task they are handling. Those are the brokers. They are agents of their principal, but handling a specific task. Whereas Dale agents, a good example is Mega Standard Supermarket. You have ever heard of it? Mega Standard Supermarket. Isn't it near Old Tax Park? Or it changed? You may find that there is now Chinatown. But by the time I visited, it was there. So these are the agents who work on behalf of the manufacturers, obtain goods, pay for the goods before they deliver them to third parties, and expect a commission at the end of the month. Agents who act on behalf of the manufacturers purchase goods on behalf of the agent, expect a commission while they are selling now goods to the third party. So they first pay for the only difference is that for them they first pay for the goods. So as if they have purchased them when they're expecting some commission. So those are the Dale Credell agents. They must work for a commission. Patents, we are dealing with innovator, new ideas. A patent agent are like agents dealing in innovations. You have written a book, you're giving it to, how are they called? Stock or libraries, where they can sell it on your behalf. You have a book, you have a movie, you have what? All those ideas that you can put into material form. Then you give it somebody to sell them, that person becomes the patent agent. Insurance, we are meaning with insurance companies. They sign with who? An insurance company signs with which person? Insurer? Isn't it called an insurer? Pardon? Who are the customers to an insurance? How are they called? The insured? Or insurer? Oh, nobody has an insurance policy. What document do you sign on insurance? Is it an insurance cover or insurance policy? The insurance policy. Then the cover is what they are going to deal in, what they are going to cover for you. Then in case of that event happening, they pay who? In case you have knocked somebody and you insured your car against accident, but then you're the one who has knocked, they pay a third party. So the company is now paying a third, but does it recover from you, or your payment now covers that expense? Now what if they knock you? What happens? Now the insurance company pays you and demands from the other party who has knocked you. So they are agents, they are middlemen in that transaction. Yeah? The only difference here in insurance, because we don't study insurance law, is that what we call a condition in a contract, normal contract, and what we call a warrant in a normal contract. Under insurance, a warrant is a major term, a condition is a minor term. Yeah, I repeat, in insurance law, their conditions are minor, their warrants are the major ones. Because they warrant you, they guarantee you that in case of this, we shall pay. So their warrants are the major ones. Here the conditions are the minor ones. But that is insurance. Don't apply it under our Contracts Act. Yeah, auctioneers, we all know who auctioneers are. People selling where the hammer falls, the highest bidder takes the commodity. Who has ever prayed from the church, village churches? What happens in the village church? Now, mostly in Christmas, they bring a goat, they say whoever is willing to purchase this can bring a man. Then you find people competing. The highest bidder, they give him that goat. The one who was selling is not the owner of the goat. He's an appointed agent. Then the money goes to the one who brought the goat, or goes to the church. That's how that also that kind of agency comes in. That the one who is selling is not the owner. The owner is now the church. The one who just brought and gave in. He surrendered, he offered. Those people accepted. So they are now in the second phase. Yeah. Pardon? Solicitors are same as lawyers. You can say lawyers, solicitors, or advocates. We as lawyers, we act on behalf of our clients while dealing with other people who are opposing our clients. So we are the middlemen also. Yeah, a lawyer acts on behalf of his principal is his client, while dealing with a person who has a grudge with his principal. Okay. Bankers, I think we know them. In a bank, the one who is working on you at the teller is not the actual owner. He's just also an agent. His principal is the bank itself. Because the bank is a company. A company has the capacity of contracting on its own. So the people at the teller are agents. Customers become third parties, then the principal becomes the bank. That's how also that relationship comes in. What have we left out under agency? Key areas of concern, know these types of agents. Know the rights of an agent and his duties as well as duties of a principal. Then the formation of an agency relationship, written, oral, implied, ratification, necessity, and cohabitation. We'll have summarized. They are all embedded under Section 117 of your Contracts Act, basically under Chapter 10, the same Act. So law applicable under agency is Contracts Act. We shift to another topic. We are yet to conclude them. Law of trust. Have you ever heard of it? Law of trust. So whoever missed out law of trust, it's a good time for it. What do we need to know under the law of trust? One, the relationship that arises from a trust. A trust is a legal relationship that arises where the owner of property, known as the settlor, puts his assets into control of who? A trustee, to manage them on behalf of beneficiaries. A legal relationship arising where, let me look for it because I see there are some people who are seeing my screen. Oh, I trace it near. Anyway, maybe I can just shortlist them. Some charge. A legal relationship that exists where a settlor, okay, the owner of assets, bracket settlor, places his property or assets into control of stock administration by trustee to manage them on behalf of beneficiaries. Yeah, so that's the simple definition. You have your own assets, you don't want to manage. Either you are of advanced age or you're busy. Some of you are over busy. Okay, so that is the trust that the owner of the assets is placing them under the control of this another party known as the trustee to manage on behalf of beneficiary. It can be created during lifetime or upon death. During lifetime, we call it inter vivo. That is the Latin word. Created inter vivos. When you're still alive, but then you can as well, even upon your death, get a person who can manage. Haven't we seen people making wills? Can a will be valid when a person who made it is still alive? Yes or no? Can you put it into play, or can you utilize it, enforce it when the owner is still alive? The will is a document which comes to be valid upon the death of the person who drafted it. And what is the name of the person drafting a will, who has made a will? Yes? Okay, when you die, when you have made a will, we say that you have died what?
Testator.
Intestate means you have died when you have done what? With or without?
Testator means when you have
Tested with a will. Intestate, where it comes with IN. Intestate without. Yeah, so you can even put the administration of your properties when you're still alive or when you have departed. If you have departed, it is also possible. How is it possible? Yes? Of course, it is possible when they go up the court and obtain letters of administration or the grant of probate. Grant of probate is when there is a will. Letters of administration is when there is no will. Yes, so you need to know those. But basically, under trust, what you need to know are the characteristics of a trust. There are only 5. What are they? Yes? Those are the 5 characteristics of a trust. There must be the one creating it, known as the settlor, the one who is going to take administration of it, known as a trustee. People are supposed to benefit, the beneficiaries. An agreement confirming the same, a trust deed, as well as the property which is under the control, trust property. Yes, please. Who had created it, Mukasa? Maggie died. Is that possible? Have you had a fact or incident? Very possible where a settlor dies, I mean where the trustee dies, and even the intended beneficiary dies, yet the actual person who created it is still alive, it reverts to him. Yeah, it reverts. But the life ended by death. By virtue of death, the life ended, isn't it? So it reverts. He couldn't get it from him before the death, but upon the death, no more life. So he can now get it back. Yes. So I think that question is fully answered. Yeah, so other things you need to know under trust, they may ask you different types of the trust. Different types of the trust. We can shortlist them. Private trust, public trust, public, private, express, what else? Yes, constructive, discretionary, any other? We have resultant trust, we have non-discretionary, what is the public trust? In simple terms, a trust which is created where the beneficiaries are the public. The settlor places his assets in the hands of the trustee for the benefit of the public. A good example are these who studied from UPE schools or UCE, government schools. Nobody. So I'm the only beneficiary. Because I started with Vietnamese, so I could be a beneficiary. Yeah, or even it could be like these hospitals, government hospitals, who has ever obtained a medical facility or medical service. So all those are part of the public trust. Government entrusts with a ministry that becomes the trustee. Then they put medical facilities for the public to benefit. That is public trust. Whereas private trust, we are seeing a person placing his assets into the hands of a trustee for the benefit of the specific people. Yeah, specific people. He may mention them, only my family members, only my clan members, only my religious followers. You can classify only for below students. Those can be your beneficiaries. So you specify, makes it private, not for everybody, but a specific sector. Express, you're going to make it, it is also private, but with Express, the beneficiaries are named and their assets are also named. That's the only difference. The settlor creates it, places it on the hands of the trustee for the benefit of individuals who are named and their specific portion. Yeah, you can name them. You may be having 10 children, you name. Out of 10, even you neglect to keep one. Then constructive, this is the trust which is created as a result of court order, where one of the trustees fail perform his duties. Constructive trust arises from court. The court order where one of the trustees fails to perform his duties, so they can substitute that person. Discretionary trust. Discretionary trust. This is a type of trust created by a settlor placing his assets on into the control of the trustee for the benefit of beneficiaries without specifying. So he leaves the powers to the trustee to determine what he will give the beneficiaries. So the word discretionary, the way we gave it, did we discuss about discretionary remedies? Yes? Under the doctrines of equity, you have already forgotten in a few minutes. Discretionary, I gave you an example that if they slap you, they give you 1 million. Another one is slapped 2 times. You can't go and claim that you double the 2 million, the 1 million. They can give him 500 shillings and he walks away. Because they can be awarded on the impression of the person awarded. Same applies to discretion, that the trustee can determine what to give the beneficiaries. Yeah, the other person gave him control to determine, so he can determine on his own paper. That makes it discretionary. Then non-discretionary, yes, please. So what to give and who to give. Yes, but of course, who to give is a matter of who are the beneficiaries. So it determines what to give. They may not be specified in private. Under discretionary. And in most cases, they may categorize. Yeah, but if they are not specified, then you can determine the two, who to give and what to give. If they are specified but not specified in the what to give, you can determine. Yeah, and how can you determine? For example, if you have beneficiaries who are one is aged 50, another one 40, another one 2 years, how can you determine? And the assets you have, let's say there is a plot of land, a vehicle, and a business entity. How can you distribute such? A 40-year-old, then maybe 20 and 3 years. The one of 2 years, you can give him what? A car. Plot of land. Why not a business that can earn him fees? You can give business the 40 year. Then the one of a kid, you give him a car. So in other words, it's discretionary. It depends. You just see what can help this person, depending on the time maybe he or she is going to utilize it. Then non-discretionary are those which are totally fixed. A person may make a will and say, upon my death, ABCD will distribute and will distribute in this way. It is like more fixed. You don't bargain. What they gave you is that one. I remember there's a will I once read where a man gave only stockings to his sibling. Stockings only. Others were given cars, plots of land, and so on. Said, ono azanya nnyo mupira, stockings. So that is non-negotiable. It is non-discretionary, fixed. Whether you take it or not, it's what they have given you. So that is part of the trust. So have you understood these types of a trust or trusts? Public, private, express, constructive, discretionary, non-discretionary. Most importantly, you need to be known the duties of. Those are the ones they ask more. So what are those duties? Duty of care. Next. Pardon? Acting in good faith. In good faith. Good faith. Yes? Accountability. Next. Distribute. Maintain. Equality. Insurance. Next. Is it all? Invest. Any other? Non-competition. Very good. If you're very vigilant, you may see that these answers cut across almost in every subject. Same duties of a trustee are the very duties of an agent, are the very duties of a partner. Get my point? You just neglect few, but most of them. For example, giving accountability. A partner will give accountability, an agent will give accountability, a trustee will give accountability. Even an employee, we shall find it somewhere that he will give accountability. So there are these answers that cut across. Yeah, any duty that I need to explain, duty of care, you know it. It must be the person who knows how to handle things, or giving it utmost good faith, acting in good manner. Duty of accountability, you must render accountability to who? He renders it to beneficiaries, not the settlor. This rules in the hand.
Yeah, so there is this duty of saying that reducing the property into possession. I really fail to understand what they
Oh,
mean for
yes,
that.
that one is part of them.
So I need
Even
some clarity about it.
is it a two?
Reducing property into possession.
Register or induce the property into possession. I think this is self-explanatory, even bad. The moment they make you a trustee, the properties are in whose name? Beneficiary or settlor? Yes? They are in the names of the settlor, the owner. So you as a trustee, you take a legal duty relationship. Because we have said a trustee is created where there is a legal relationship. So in other words, under the law, they are looking at you as a person to perform. So the first thing to do is to register them into your name. But then you don't put your name as if you're purchasing. You put your name in bracket trustee. So it must be on each property. If it is the land, you can apply to land ministry. Then they put that property and they put you as a trustee. Of course, they can't just put you without evidence. You must show them where you got powers from. That means you must have that trust agreement, the trust deed. Didn't we say that is one of the characteristics? Then you must also show the IDs, the national ID of that person, your own national ID, then whether you open boundaries, a search you made, everything. Even if it is a car. So you change them into your names. You just get them from the names of the one who gave you powers into your own names with the word trustee at the end. So that is the duty about you're talking about, the duty to register or induce the property into possession. So you take, even if it is now, if they are tenants, what do you do to them? You keep quiet and you came as a mafia, or you come and introduce yourself as the one in charge. Yes? They have given you, let's say, entire winter cake. To manage as a trustee. What do you do? Can't you come and introduce yourself that from now and onwards, and even issue them a notice? Those are the things they expect under the duty of possession. Issue them a notice that from today and onwards, I'm the one in charge by virtue of maybe this agreement. So that now you transform everything. So it is your duty. Anything we left out? Surely.
The law applicable, you don't state it.
Okay, the law applicable. Under insurance basically has a duty that you as the trustee, you can insure the remaining assets. Yeah, because insurance helps in the future aspect. And now that it helps the young beneficiaries, those who are below 18, also benefit effectively. So that is with the insurance. But also it depends on the assets. Good example is where you have vehicles and they are involved in accidents and you all remain with like 3. Can't you sell one and you insure the remaining? Yes? The law applicable. Law applicable is known as trustees Corporation Act, as well as the Trustees Trustee Act. Those are the 2 laws. You can select one. Then ways how a trustee can be terminated, things that a trustee can do, and these laws come to an end. Ways of termination of a trust. Can we outline them? Termination of a trust, number 1, expiration of period. Because it is a contract. So if it comes to an end, becomes it. Expiration of period or time. Number 2, performance of his duties as a trustee. You perform your duty, then the trust can come to an end. Number 3, where there is a court order prohibiting you from further performance, the trust can come to an end. Number 4, consent. Consent of who? Of all the beneficiaries. One beneficiary cannot remove you from office. It must be consent of all beneficiaries. Insanity of who? Those are other points that still remain concurrent. Insanity, death, all those still. Then notice, retirement. Those are the points that really still will always remain at the tip of your mind. Retirement of the trustee or trustee. If people get tired. Under the trust, I think there is a specific age. But even if it is not in the act, if it is in the agreement, then you can, at that moment, you can now retire. That is it for law of trust. Any question on that? We have left law of trust. Which other topic? Law of tort. Under tort, the law applicable is common law. Common law is the law applicable under tort. What is a tort? A tort is a civil wrong. Civil wrong. A tort is a civil wrong. At common law. Which remedy is what? Damages. A civil wrong at common law, which remedy are damages. A person who commits the tort is known as, those can come as an objective. A person who commits the tort is known as or some of you will call it professor, but it's okay, we shall wait for the final. A tort feaser or tort facer, the person who commits the tort. Yeah. What you need to know under torts is that number one, we have things like negligence. What is negligence? It occurs where there is a duty it has been breached and as where there is a duty, then that duty has been breached and has caused damages. That is negligence. There is a primary duty of a person to perform. That person has not performed that duty. As end result, there are some consequences or damages. A good example: if you have a house and you see that it's in a dilapidated state, what is your duty as the landlord or landlady? Renovation. So in case you don't renovate and it falls on the tenants, who is supposed to incur the cost? Tenants or you, the landlady or landlord, something like that. So that is negligence, that whenever there is a duty to perform, then you fail to perform that duty. At the end, it causes damages. You're liable. If you're driving and the only way you know that before you knock that person you need to brake, you fail to brake, you know who should be liable? Yes? The driver or the passenger, the other person crossing. And that is with negligence. That whenever there is a primary duty to perform, you fail to perform, then you're liable to damages. So the key elements in negligence are three. One, there must be the duty. Two, the breach of that duty. And three, arising to damages. Only those. There is the duty to perform. The duty has not been performed. As end result, damages. Yeah, once we are done with those, we have two types of damages that I will make it clear. In Latin, we call them daminam in injuria and injurious in daminam. Those are the two types of damages. In legal way, we say that these are damages arising out of the injuries. Yes, physical injuries. Or you can claim for damages without physical injuries. Don't you need to be like impedance? Learning law. So what are the damages that may come without physical injury suffered? The person who may abuse you makes a defamatory statement. What do you lose when they abuse you? Or when they ill talk about you? Are there physical damages you will suffer? Yes, I can try those terminologies in the next time. Okay, let me give you a spade. I don't have any problem with giving you spade. Daminam sin injuria and injurious in daminam. But one says that there are some injuries you may suffer without, there are some damages you will suffer without a physical injury. Yeah? For example, a person abusing you, you lose nothing apart from your reputation. But then, if a person gives you a heavy slap, then you find that your cheeks are swollen. For example, in the names of Matamabu, can't you claim for damages which are this heavy? Yes, please. Damages? No, 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 no. We have various types of damages. What I will tell you, ranging from general damages, specific damages, punitive damages, exemplary damages, mentioned but a few. Yeah? But these damages were basically meaning that you may claim for damages out of a physical act done. For example, if we all know we are going to see under a law of tort still, trespass. I don't know why I'm not seeing the work of. Yes, I'm not seeing the work of torts. I think we may get it, but for the interest of time, I will. Once I land on them, I will just share them. Have we first of all understood what negligence is? Then, after that, we need to know three categories how it arises. One, we have trespass to person. And under trespass to person, we are going to write these terminologies because they may come. They may ask you scenarios following under that. Trespass to person. Number one, we have battery. Battery, yes. Those are trespass to person elements of tort, but basically under trespass to person. Battery, assault, false imprisonment, malicious prosecution, wrongful arrest, defamation, you can as well put nuisance. How many are they? Are they like 6? 7. Let us define one by one. We begin with what? Battery. Battery basically means an act, a physical act done on person without his consent, arising to damages. Physical act done to a person without his consent or permission, arising to damages. That is battery, basically. What could be a good example? An act done on you without your consent that may cause some injuries or damages. Rape. This is still here, part of battery. But as the physical act, they may slap you, they may cut your hand, they may do what, anything they may do on you or perform on you without your consent becomes battery. Any physical act, rape can be part of it. Because you can't rape by words. You? Words may actually only form sexual immorality, but not rape. So rape is part of it, but beating can be like battery form. Because we have where they can do it when you are consented. Haven't we seen people in wrestling? Don't they consent? Even what? Films, they consent. But is the film a practical aspect? I don't know, I've never watched any film style. I can't testify on that. Okay, so that is the battery. Assault, we are meaning apprehension of fear. Assault is an apprehension of fear to a person that something bad is going to happen to him or her. Apprehension of fear to a person that something bad is going to happen to him or her. That is assault. Assault. Apprehension of fear that something bad is going to happen to him or her. What could be a good example? Apprehending fear that something bad is going to happen to you, done by the other part, of course. For example, if a person gets out of his room with a kettle of what? Boiled water, then he scares as if it's going to power. Can't you apprehend some fear? Or some of you are fearless? So the moment you apprehend that fear that something bad is going to happen, maybe it's going to power what on me, becomes assault, you can go and sue him in court of law. That is automatic case in civil. You can go and sue. For battery, that act must have happened. If you try to power, but then you have to excuse yourself without water dropping on you, it becomes assault. Even if it is a drop that is on your body, it changes to what? Battery. Yes, because now there's a physical interaction on your body without consent. Then what was the next point? False imprisonment. That is basically false imprisonment occurs where a person is infringed with his right of movement without an escape route. Where a person is prohibited or is not granted his right of movement or infringed on his right of movement without an escape route. For example, the one who has gotten out can look for us inside. Whether we are aware or not, that is false imprisonment. So you don't need to be aware or not. The moment you don't have an escape route and your right of movement is restricted, it becomes false imprisonment. Because if you have an escape route, then it's a different story. Next, wrongful arrest. A person arresting a person without permission or consent or warrant. A person arresting another without a warrant or consent. Wrongful arrest. Next. Pardon? Then that? Abduction, no. And abduction comes from country A to another country. No, that is the Caution, no. But adoption, I mean, that act, no, it doesn't fall part of wrongful arrest. Who is every time a person is supposed to arrest or effect an arrest should come introduce him or herself, tell you the reason why he wants to arrest you, show you the documentation allowing him or her to arrest you, then he takes you. The moment he fails to follow that procedure, then he's doing a wrongful arrest. Abduction, in most cases, they are speaking you, then they take you somewhere without even any justifiable reason. But here it could be with a justifiable reason, but not following an order. Yeah, most cases, whenever they get you under trespass at night, the trespass where they just find you on the road and they take you. Idle and disorderly. Yeah, but they changed it. Is now for it's called what? Vagabondage. That's the current law of substituted to idle and disorderly. Vagabondage. And they normally change the terminology. So the person who's supposed to arrest, first ask him, how are you, officer? What is your name, Okero? Oh, Okero, I never studied with you. What's your problem? Then they elaborate. Better to do that, that's the wrongful arrest. He will take you, but you can come and sue him for arresting you wrongfully. What was the next? We completed it. Restraining one's movement without an escape route.
Malicious prosecution.
Malicious prosecution means a person drags you to courts of law in a criminal matter, then they dismiss that matter without for failure to produce evidence or for failure to have a justifiable reason. You now sue him in civil courts for wasting your time. So malicious is like wasting. Then prosecution are the court proceedings. So wasting your time in court proceedings and a criminal matter. So they must have taken you to criminal matter. They dismiss the matter in your favor. So you're now in need of compensation. You come to civil, and your cause of action is malicious prosecution. Defamation, false statements. Defamation are false statements made by one party to another. In tendering, false statements made by one party to another, tendering to lower his reputation in a right-thinking member of society. False statements intending to tarnish your name. False statements made by one party to another, intending to lower one's reputation in the eyes of the right-thinking member of society. Because what could be defamatory statement could be different if it is given to another person. Yeah, there's a time when was it Tamagus? There's an MP who made some statements about his name, but then he was claiming that in their tribe it's a good name. Actually, the one Tamagus, the bad one, then the one they substituted was the good one. Yet here in Uganda, I think that name was now sounding to be the worst. Those are defamatory statements. Yeah, what next? Trespass to land. I will just basically give it 2 lines. Are we done with trespass person? Nuisance. You see there? Okay, nuisance arises where? Pardon? Who? I did his name. There's an online student who was making a comment, only that I've forgotten your name. Not bad. Yes? Esther. Esther, you have a comment?
And no, sir, I don't have any comment.
Okay, let us try to summarize. Maybe after that we can go through some numbers and we again resume others. Oh, you have questions? Nuisance, that is the continuous act done by one party. A continuous act done by one person or one party, depriving another person's liberty or right of enjoyment. Continuous act done by one party, depriving another party's right of enjoyment. That is nuisance. For example, we all have a right to live in a healthy and clean environment, isn't it? So for you, if you open your sewage, how do you expect me to live in a clean and healthy environment? The moment it becomes continuous, I sue you for nuisance. If you make it a one-time event, it is okay. May not amount to nuisance. So it must be a continuous act, depriving the other party's right of enjoyment. It is in two ways. If it is affecting a particular individual, it becomes a private nuisance. If it affects the entire community, it becomes public nuisance. You need to know negligence and a lot of torts. Not negligence. What is it called? Vicarious liability and a tort. So what is a vicarious liability? It is both in employment and law of torts, and the same definition cuts across. So what is vicarious liability? It occurs where an employer stroke master is liable for the acts of his servant done in the course of employment. Vicarious liability occurs where a master is liable to the acts of the employee or a servant done in the course of employment. You need to be knowing that. So they will bring you facts. They tell you that this person has been working with this for the last 10 years. However, last week he did A, B, C, D contrary to his duties. They want to sue him, but he's claiming that his master should be liable since he was acting on behalf of the master. The only question you want to ask yourself is, was it in the course of employment? The moment you find that it was not in the course of employment, you will be personally liable. If you find that it was in the course of employment, his master will be liable. They may bring facts which involve like this police officer, because we are in political period, in the election period. They say that they were seizing the rioters in a campaign. Then this police officer shoot dead one of the people who were at the rally. The family of the deceased is claiming compensation from this A who shoot. A claims that the government should be liable since he's an employee. Advice. Your question is, was it in the course of employment? If you find that it was yes, then you will say that the other people are vicariously liable. His employer, the government, should be liable. The moment you find that he was deployed in Kisoro, then on that day he had just gone home and he had a uniform, he wanted to show off the village people that he's one of the trained military guys. And then he had to shoot in the riot. Then he is not under the cost of, because he's employed in Kisoro, he's shooting in Mbari. There the government can't be liable for his acts. I work on that member. So you just master whether it is in the course of employment or not. You need also to understand strict liability and what as the last element, strict liability. And with strict liability, we are looking at two things. A person bringing something into his land, that item escaping, causing damages. Strict liability occurs where a person brings or collects into his land anything that may escape and cause damages. Strict liability occurs where a person brings or collects into his land any item which upon escaping causes damages. An example is if you're rearing dogs, they escape and bite a person, they are going to sue what? Can they sue the dogs? Because some dogs have names. German Shepherd versus Atuijuka Jr. They don't sue the dog, so they sue the owner of the dog. So you're strictly liable to your dog. Strict liability. The liability shifts that he who brings something into his land, it escapes and causes damages, is the very person liable. Okay, that being aside, so even same applies to where you bring, let's say, ponds, they pass road to, water washes away crops of your neighbor, you're the owner, you're liable under strict liability. Defenses that we may raise in law of torts, we can list them. General defenses, act of God is number one. Act of God, the real God, G-O-D. Act of God, what do I mean? Natural calamities. Yeah, act of God, we mean natural calamities. Thunder, you were coming to take shelter under my tree, then thunder hits you, or hits your friend, you paralyze, you suffer some damages, you want compensation. Kuma will claim that it was an act of God. Yeah, so that is one. License or permission is number two. License or permission. If a person is arresting you and you answer him for wrongful arrest, yet he had a warrant or a permission, you cannot succeed. Number three, contributory negligence is a defense. You contributed to your own negligence. Didn't we study what negligence is? A duty where you have a duty, then you breached it. Now, in case they knock you when you are putting on headset, don't you think you have contributed to your own negligence? Then another defense, we can say, which other defense can we put? Inevitable accident, something you can't control. Inevitable accident. I may have planted a tree, but for you passing by at that time, if it falls on you, it was inevitable. Because you may now start saying, now strict liability, why did you plant a tree which grew well and now has hit me? The only defense is inevitable. Yeah, something you can't control. Inevitable accident is part of the defenses. Then truth is a defense under defamation. So that the other person says that you issued out false statements, you can say they were true. Person may say that you may make an article saying that a person aborted 10 times and yet is being a nun or being enthroned as a nun. If you have proof that indeed you, by then you were a doctor and you examined him, or you were she was aborting from your facility, that becomes true. What else? Privilege is a defense on defamation. Privilege. Any other defense? Privilege. Privilege, we are basically under defamation. There are some, like a president, is privileged some aspects. He may make a speech and you can say that that is a hated speech. That's that immunity. Okay, privilege or immunity. Yes? What? Opinion. Yes. Opinion is a defense to defamation also. Opinion, fair comment, all those are defenses of defamation. A fair comment, what this man normally does. Who? Makona Brian of Uganda. Mbu, then he asserts that word. There is keeping liability. He's defending himself because he's claiming that somebody mentioned it. So he's replicating that word. So it becomes the defense of defamation. You can't sue him for defamation. That is a fair comment. Also an opinion. Some people now claim, bring just an opinion. In my opinion, you are a fool, an idiot. Then you answer that person. But he has said in his opinion. And your opinion can't be his opinion. Yeah? So those are some of the defenses. Closing chapter of thoughts. Key elements: understand negligence, understand those strict liability and vicarious liability. Let us go to company. I know it is white, but most of you must do it in an exam. I think, but before company, let me go for the crucial topics now. Cooperative societies, before you get tired. Act governing us, cooperative societies, act. There's a funny noise that I'm competing with in the background. Okay, thanks for that, for knowing your error. Cooperative societies, it is the must-do number in your exam. Because in the last 5 settings that has been occurring, I don't think you're exception. Law applicable cooperative societies, act. Number one, you need to know the definition of what a cooperative society is. Yeah? What is it? What is a cooperative society? Who can remember it? No one. Or we don't have it in our syllabus. Okay. Cooperative society is a business relationship formed by members of the same jurisdiction with a minimum number of 30 who have capacity to improve their socio-economic aspect of life. A business done by the minimum number of 30 who have capacity from the same jurisdiction with an intention or with an aim of improving socio-economic aspect of life. That is a simple definition of cooperative society. Key areas, you can highlight them. Number one, same jurisdiction, same area. You cannot be a member of Mbarara Cooperative Society when you're staying in Entebbe. You can't be a member of Jinja Cooperative Society staying in Kasese. Possible. You must be from the same jurisdiction or area. Number two, the minimum number are 30 members. In what do we say that the minimum number for partner? Minimum partners.
2.
I'm hearing minimum 20. So minimum in a partnership are 2. Maximum are 20. In a partnership, in a cooperative society, minimum are 30 members. Maximum infinity. Yeah. Then
Yes.
improving their socioeconomic aspect. There's a question on, right?
No.
Okay. So another aspect is that they must be aiming at improving socioeconomic aspects. They normally ask about membership in cooperative society. So for one to qualify to be a member, these are the things they must consider. One, he must have paid subscription fee. Number two, his name must be appearing on the register. Number three, must come from the same location or jurisdiction or area. And the last, he must be of what age? 18 and above. The exception, section 5 of your cooperative society gives those elements that for one to qualify to be a member, paying subscription, coming from the same area, and 18 and above. That is section 5 of cooperative society. Section 13 gives an exception of a person who is not of 18 years, but he can qualify to be a member. So they go to which age now? If you're below 18, even a person of 12 years and above qualifies to be a member under section 13 2B. Section 13, subsection 2B of your Cooperative Societies Act. So in most of the exams they have been setting in terms of membership, they will tell you that one is 23, another one is 17. Other members are not up on admitting those two members. So your question is, can a person below 18 qualify? And the answer is that yes, he can qualify provided he is above 12 years age. But the only difference is that if you're above 12, you're also limited to what? You cannot sit on any, you cannot spearhead or you cannot lead any committee in a cooperative society. You don't lead any committee until you obtain 18 years. Is that okay, members? So in case they bring an aspect of age, just know that even one below 18 can qualify. Unless if they go for 11, 11-year-old does not. So it must be 12 and above, but a 12-year and above cannot qualify to be on any committee as a committee member. Okay, that is clear for membership. Another aspect to understand more in cooperative are the rights. What are the rights of members? Those rights cut across also on the rights of members in a company. So what are the rights and what are the obligations? Well, they are different, or they are the same. A right is an entitlement. An obligation is a duty. So let us go for, we begin with what? Rights. What are their rights? What are their entitlements? These are the general things you just need in an exam to write. Just look at the community where you're staying. Since there's many people, you equip them to be 30, and what are the benefits you get? Yes? Or before we go for rights and obligations, we first understand what amounts to socioeconomic. That gives us those rights. Okay, socio-economic aspects in cooperative society include, okay, activities that fall under social or economic include the following. Socially, we are meaning people can now construct roads, can build churches, mosques, schools. I don't know whether they can also build shrines. Anything that can gather many, markets, and everything. So just look at the general life. One thing can associate more than 10 people. Then you say that that is a social aspect. Yeah. Then economic, anything that can generate income. farming, fishing, poultry, teaching, what? Anything that can generate income falls under economic. Then at the second way, you can now look at the aspect that if you're a member and you qualify, for example, you're an accountant, they have schools, what duty can you perform? They have banks, they have circles. What are your roles as an accountant? In case you're a member and you're a lawyer, what are your duties? You get the point. That one helps you to generate all the rights of members. That are even the obligations they can do. That it is an obligation of a member who is the lawyer to harmonize disputes. An obligation of a member who can be an accountant to make internal audits. Yeah, it is an obligation of a member to you bring every aspect that goes there. So this is the general terminology, what I can say. So what are those rights? A right of the rights you can get, you can benefit from, or you can your rights as a member of cooperative society. A right of accessing books of record, attending meetings, voting in meetings, participating in decision-making policies, actively participating, sharing profits, contributing to losses. All those are the things they expect. Then the obligation, now what you're supposed to do. Paying subscription fee to qualify to be a member, ensuring that the company complies with the statutory requirement, the cooperative society complies with statutory requirements, that's the obligation. Ensuring that they act within the procedures and internal regulations, those are your obligations. Then lastly, they may ask you who registers it. Obviously, is the registrar of register of companies, register of cooperative society. Then the last is about how that cooperative society can come to an end also. Almost each topic, there's the way you form it, and there's the way it comes to an end. Even in formation of the cooperative society, what do we need? Paying subscription fees, signing on memorandums and articles of the association, and so on. Getting the registered place of address, those are the things that they require before they register the cooperative society. Ensuring that the minimum number are 30, those are the requirements for registration. Ensuring that they come from the same jurisdiction or same area. The exam may now come in a way that they are telling you that Mengo Cooperative Society is a society whose members are those within Mengo and surrounding areas. It has been effectively operating for the last 2 years. Musoke, who comes from Natete, has paid subscription fee, but they have the secretary has not endorsed on his membership. Other members are insisting that Musoke should not be part of them. Musoke insists that he also is entitled to profits. Is entitled to the right like any other member. Musoke is before you seeking for advice. What are you going to advise? Whether Musoke is a member of Mengo Cooperative, is he a member? Comes from Nated, is he a member? The question is Mengo and surrounding areas, is he a member? Yes? Mengo is near Nated. So is he a member? If they say and surrounding areas, and you have said is near Natet, does he qualify to be a member? Yes? He qualifies. So it's a matter of question interpretation. They have said surrounding. Unless if we never studied social studies. But the word surrounding, then we are meaning also within. So unless if they could say now the same facts and they say Mustoke stays in, maybe they bring another area. Kawempe could be quite far, but in Atete comes nearer. So you now qualify it because of the word surrounding area. Okay. You must also know that cooperative societies conduct meetings. General meetings at the end of the year where they can appoint other people in the team. Under cooperative society, you also need to know that in case of dispute, there are disciplinary committees that can handle. Last year, you need to know that a cooperative society can come to an end by what? Liquidation of a cooperative society. Number one, their own report. Voluntary winding up 2. Creditors winding up 3. Court 4. Creditors subject to court supervision. The registrar. You can go to court. Okay, court and quasi judicial courts can even add that, like things acting like court would be now the office of the registrar. Yeah, but the same modes of liquidation of a company are similar to the cooperative society only that what you're substituting is the word company to cooperative society. Same element. We are done with cooperative society. Yes, please. No, the last time they set an exam was dealing with that Ginger and its neighboring areas. Then they brought Kamuri. So however much I'm not a Musoga, can't I at least determine that Kamuri and Ginger are near? So that's the logic of knowing. At least now if you haven't moved totally, yeah, you're staying in Fort Porto, you may not distinguish. They don't neighbor each other. Ginger and Kamuri, they don't neighbor each other. You're saying they are, and you're saying the moment they neighbor is sufficient. Those are just I know that is it Luka district, something like that. Those areas that surround Ginger. They can bring those aspects. Yeah, but emphasize on the membership aspect and also the elements. I'm done with cooperative societies, banking. What do we need to know about banking? The relationship that exists, a bank customer relationship. For a bank, for one qualified to be a customer of a bank, there must be a bank customer relationship. Pardon? Law applicable. Bank of Uganda Act, Bank of Uganda Act, Financial Institutions Act, Bill of Exchange Act, case laws. Yes, Bank of Uganda Act. You have it, it is an act. Redress all the financial institutions. Bill of Exchange Act. Financial Institutions Act. Case law, among others. Because I won't mention all of them. They went from tier 1 microfinance, tier 2, tier 3, tier 4, and so on. But those I will not mention at this stage. I think those are the crucial ones are Bill of Exchange and financial institutions, as well as maybe Bank of Uganda. Okay. Who qualifies to be a customer? Of course, we all need to know that. Basically, if you want to be a customer of a bank, you must be having an account with a particular bank. No matter which form of an account, whether saving account, deposit, trade, partnership, cooperation account, anything, must be having a particular account with a bank. And it is only the bank where you have an account with that you qualify to be their customer. Yes, if you have only in Centenary, you don't qualify to be a customer of Equity Bank unless you go and open up an account. Key important things to also know are the bill of exchange, the various types of bill of exchange. E.g., a check, a promissory note, the layaway receipts, among others. What is a check? A bill of exchange drawn by a drawer, payable to the payee on demand. That word must not miss. A bill of exchange drawn by a drawer, payable to the payee on demand. What is the promissory note? Bill of exchange. Yes. What is a promissory note? Doesn't have a meaning. Yet they asked it in the last meeting. Okay, since it doesn't have a meaning and they asked it, they will forgive us. They will ask us simple things we have studied. Duties of a bank towards the customer. Duties of a bank towards customer. There are only how many? Two. One. Actually, there are three. There are three. One. Pardon? A duty of secrecy. We are basically saying that a bank has a duty to keep confidential information of its customers. So it is duty now, yeah, it is one of the duties. The bank has a duty to keep confidential information of its customers. Exceptions to that duty. That's exceptions. That's instances where it will not keep that information. What are those instances where it will not? Where there is a public request or public duty. Public duty or public request. For example, if they suspect a customer of a bank funding terrorists, the bank will release your information without your consent. Number two, where there is a court order. E.g. what? What are the examples of court orders? Two of them, Maleva injunction and what? A garnishee order. See some of those who have never attended banking, but they work in the bank. They hear them on the counter, also hearing them from the bosses. Now they are supposed to do them in an exam. Because they said last time that what of briefly explain the following: order, bill of exchange by order. They only wanted one to say, this is a bill, this is an order from court. e.g. a garnishee order. You have your marks. Or if the moment you say that an order made by a court instructing a bank to pay, that was still a full mark. That's all we need to be clear. I think we know what garnishee orders are and malleable injunctions. What is a garnishee order? Who attended my last session? What must have been on banking. Okay, this occurs under garnishee. It occurs where a person who is being demanded. Okay, a person gets a court order against another party who has an account with the bank, whereby the order directs the bank to pay from the account of their customer to the one demanding that customer. So it becomes the garnishee in that way. That you just find out whether he has money on the account, then you summon a bank to pay this person who is demanding. So he's not a customer of the bank, but he will benefit under a garnishee. With a malleable injunction, that is still a court order restricting a bank to make any other transfer unless their customer clears up with the person demanding it. So it is like a court order stopping them dealing with the assets of their customer, or allowing the bank to freely use, or not allowing the customer of the bank to freely use the assets which are under the bank control. You may have mortgaged your land title. So with an malleable injunction, they are like, don't release that title to him. Get a point? They are directing a bank and not release that mortgage security simply because you're still demanded. So it becomes a malleable injunction. Okay. Any other exception? Yes? Investigations by IGG are exceptions to the duty of secrecy. Pardon? Yes, where the customer requests from the bank will release or will issue a statement. Where a customer of the bank sue the bank will use his account information as evidence, so it will breach the duty, among others. Duty number 2. We have already mentioned the duty of separate. What is the second duty? Honoring customers' mandate. Honoring customers' mandate, like respecting what the customer's mandate is, the duty of the bank. Second to last. So if a customer is requesting for an overdraft, you can honor it. It is your mandate to honor it. If he's requesting for pay, you honor it. Second to last, duty of skill and care. It cuts across also in agency, in where it is now in banking. The duty of skill and care. Those are the 3 duties expected from the bank. Now, what are the duties the customer is expected to perform towards the bank? Duties expected from a customer towards the bank. Duty number 1, drawing a check with reasonable skill. Yeah, drawing a check with reasonable skill and care. So drawing a check, we mean to avoid errors. You find that you're writing S as 5 as S, 0 as E, yeah, 7 as 1, those errors. Then number 2, informing the bank about any forgeries the customer is always aware of. That's the second duty. Customer to inform the bank about the forgeries, about the forgeries is aware of. As you appreciate those, you need to be known characteristics of a bill of exchange, because they can ask them as a direct question. Characteristics of a bill of exchange. There are only 5. There are not many. There is a transferable, that is number 1. Is a transferable. Certainty of the payee. Must indicate the drawer. What else? They must be negotiable. Any other? Must be acceptable. The acceptable part of them. Okay. Once we say negotiable, what do we mean? Because that's the big word that I'm saying in that point. Negotiable, we are meaning the bill of exchange having right to transfer ownership. Yeah, if you give me a check, the bank must now deduct from your account to my account. You need to be knowing parties to the bill of exchange because they are also examinable. Parties only. Who is a drawer? Who is a drawee? A payer, payee, order in due course, endorser. I repeat them. 1, drawer, the person drawing a check. So he's the customer of the bank, drawer. Number 2, a drawee, that is the bank to whom a check is drawn. Payee, a person to be what? Be paid, or a person named to be paid. A bearer, person in possession of a check. Before it is initiated. Then we have a holder. You have a holder in due course. You have an endorser. So they may just say briefly give 5 of them. Must give. An endorser becomes this person who is approving or initiating another transaction. They may have named you to receive money, but you want to pay another person. So you endorse. You acknowledge that they pay the other person instead of you. You become an endorsee. Limitation, you don't bring a suit. Okay, you ways of dishonoring a check before limitation. Ways how a check can be dishonored. Number 1, if it is forged, where there is no request of an overdraft and amount requested is much compared to what is on the account. What else can render the not complying with the working hours? Presentation of that check or bill of exchange after 6 months. Where there is a valid court order, e.g. a garnishee order or a maleva injunction. Where it is presented by a fictitious person or a non-existing person. You can use any of those words. Where it is either presented to, by or a person to be paid is a fictitious or a non-existing person. Yeah, you may be knowing that a man is known as Bobby Young, yet his names are not Bobby Young. Then you issue a check in Bobby Young's name. Can they honor it? That becomes a non-existing person, fictitious person. Limitation, you cannot bring a suit against the bank after 6 years pertaining the last transaction. After 6 years, court cannot allow you, unless if you have a justifiable reason. Yeah. So that banking chapter, we have also closed it. And no, maybe before we close, we may go for what types of endorsements. Types of endorsements. You have restrictive endorsement, conditional endorsement, blank or special endorsement, what else? What is the last one? It's supposed to be 4. Restrictive, condition, maybe non-conditional. Non-conditional endorsement. I think you know the meaning of all of those. Any that you don't know about? If yes, which one? Are they familiar to you people? Okay. Which topic haven't we covered? Do we need another break? No. So I'm going to wrap up. Okay, let me wrap on employment, because there's also a good number they can set. Employment, Law Applicable Employment Act. Types of employment, 3 of them. 1, contract of service. 2, contract for service. 3, independent contracts. Well, you have a challenge, ask, because we are out of time, but we need to appreciate just. Applicable, I've said Employment Act Cap 226. 3 types of employment contracts, 1 being contract of service, contract for service, and independent contract. Under contract of service, it occurs where an employee works under the instructions of an employer on how to do the work, when to do it, where to do it, from, under the course of duty. We agree on that? Contract for service, an employee is particularly giving services, professional services to the employer, e.g. an accountant, a lawyer, and so on. Those are under contract for. You're providing particular services. And lastly, independent contractors or independent contracts. This involves independent contractors with the employers, where you give him or her the work schedule, you pay him, and you wait for the agreed terms for any fulfillment. You only pay him what he has requested before, and he does the work according to what you have agreed. So no expertise needed. You need to know the various tests we apply. Tests, e.g. under contract for service, we apply control tests. They are controlling you on how to do the work, where to do it from, when to do it, and what to do. Control test goes for contract for, contract of. Entrepreneur test or entrepreneur test goes for what? Independent. Yeah, entrepreneur independent. Then integral test goes for contract for service. You're forming part and parcel. Well, the moment you're providing services to determine whether you are an employee, we first see for whether there are services you're rendering. Yeah, so you come part and parcel the contract. So there are control test, integral test, and entrepreneur test. Apart from that, we have already talked about the career side bit. You need to read it. It cuts across in employment. You know that when you're doing work, when you're guided by your employer, then you will be liable to pay. Only work done in the course of business. Exception is if you do work, even if it is work guided by your employer, then you do it with negligence. Yeah, you don't mind on what you're doing, then you'll be liable. They are saying that maybe wash clothing or what, washing as well as when you're on TikTok, end up, putting strains, then you will be liable. What you need to know basically in employment again are the rights of the employees and the duties of the employers. They normally ask on duties. I will emphasize duties of employers. Rights of employees or duties of employees are few. A duty to work, following lawful instructions. Just like for agents, copy agents' duties, apply them under employees' duties. Then for employers, they go an extra mile. Some of them apply, some don't. Duty number one is the duty of an employer to provide work. That is the duty of an employer. To remit taxes which are withheld. It is the duty of an employer to create conducive working environment. The next, a duty not to discriminate, and now they normally ask on that aspect, that duty. They will bring set of facts indicating that this person was discriminated because he was HIV positive. Yeah, he was not promoted because they had no levels of education. Because he's a Muchiga, a Mutoro, Mnyarwanda, something like that. Because he's a Catholic and they are employing, they are promoting Muslim. So all that is the duty of discrimination, which is against. Every employer must safeguard employees against any form of discrimination. Then we have sexual harassment. It is the duty of an employer to protect all employees against any form of sexual harassment. The law says where you have more than 25 employees, you must ensure the safeguarding of their any form of sexual harassment. Yeah. And sexual harassment is defined under your note. Advances related sexual nature. I don't know what advances are, but it's a term which is there. What are the advances? You also don't know. Who knows advances they are talking about? Advances which are related sexual in nature. They are gifts. So every gift is a sexual advance. Separate gifts. So the moment you bring it at night and it is covered. Okay, so you will know what sexual advances are. Those are like requests.
Outing
Then
with
also the word. Yes, Bahati?
like an employer taking the employees for outing.
An employer taking you see, he has a point. Employer taking an employee for outing. So you mean the employees don't go for out?
The employee should go themselves, not with an employer.
So for you can't go with your boss who is the man because you are an employee, is an employer.
At what time and where?
Even when it is the same sexual gender you fear. And you ask where. So anyway, you will know what sexual harassment is, because they define it as sexual advances, they define it as sexual words, words which are in nature, like equity, they are defined. Yeah. Also, bad dress code that may entice is part of the sexual nature which every employer must safeguard all employees against. Yeah, if you dress badly and you have your employer can safeguard, you can eliminate that person to ensure that others work well. Yeah, and so on, and also what is use of sexual material. Yeah, find that the office is full of some CDs instead of books. Yes, you go and read, the definitions are there. Sexual objects. Anyhow, so those are the only duties. Yeah, very many. Please go and visit duties of employers. And you master each. Then you know the termination period. Termination of employment. If you have worked for less than 6 months, what is the period that you're supposed to be given a notice of termination? 1 week or 2 weeks? 2 weeks or employment in levy. In advance. They should pay you in advance, only 7 days, or they can give you 2 weeks notice. If you're less than 6 months, which we normally call probation period. Then after 6 months, but less than 1 year, you're also entitled to 2 weeks notice. After 1 year, but less than 5 months, 5 years, a 1 month notice. They should issue you a notice 1 month before they terminate you. Then after 5 years, but less than 10, 2 months notice. Then if you're a veteran, after 10 years, or you have been there ever since 10 years and more. Not 6, we don't have a 6 months notice, it's 3 months. 3 months notice. Or payment in advance. They are all entitled to payment in advance. But all in all, it also goes to the terms in a contract, depending on the notices you indicated. What amounts to unfair termination? Things that we can consider to be unfair termination. Where you're under sick leave, they terminate you. Where you're under maternity leave, they terminate you, or paternity leave. Yes? Termination without notice. Terminating you under discrimination. Okay? Any other? So all those are amount to unfair termination. There's a big difference between unfair termination and summary dismissal. They are different. Summary dismissal means terminating you or dismissing you from work because of a gross misconduct. A gross misconduct. Something that cannot be tolerated. And examples are persistent drunkenness, persistent late coming, incompetencies at work, among others. Because if you're incompetent, you may come and see us that you're an accountant, yet you have even never attended any school of accountants. So you go and master those. What else is really crucial? What happens when they terminate you unfairly? You sue to who? You lodge a complaint to a labor officer. or you are from a labor officer, you can now advance to court, which is an industrial court. It is a court designated for the employees. I think that is also captured. Okay, what is the next in employment really? Maybe in terms of payment.
There is what they call allowable deductions and unallowable deductions. Like in most cases, like which allowables can be deducted minus the cost of an employment of employee.
Those can be, but those can always be in a under the express terms when you're signing the contract. Don't they indicate what they can deduct from you? Yes?
They do.
So maybe now you're pushing us to know what are the express terms and implied terms in a contract of employment, yeah? We can talk about them briefly. Express terms are those terms that you sign. Because they may just say that give 10 express terms in a contract. What do they need? Whoever has an employment contract or appointment letter, you must be having those terms. It must bear the date when you started or when they issued that letter. It must show the position, isn't it? It can indicate the working hours. Does it indicate the salary? What else? The complaints, where you can note your complaints. Next, the benefits. Any other? Those clauses which are in your contract are the express terms they are meaning. The location where you will work from. Then any other? So all those are the express terms, remember. Then the implied terms in a contract of employment, we are basically meaning those terms which are not written but must be followed under the law. Nobody will put for you that when you're sick, you're entitled to a sick leave. It becomes an implied term because it's in an act, employment act. So these other benefits that you must be obtaining, yet they are not in the contract, become implied terms. E.g., sick leave, leave with pay, maternity leave, paternity leave, and others. It is also an implied term under common law that you must cooperate with other people you are found at work. The duty to cooperate is also an implied term. Or if you come when you don't want to cooperate, you have breached the duty and they can terminate you. So that is also covered. I think employment we have covered. Maybe a key point to add, in case they bring a scenario where they're indicating that this employer wants to pay an employee from how are they called? These places of enjoyment. They called amusements. Yes? Amusement places. The law says it is not advisable. Unless if that person works in those amusement places, so anything you pay an employee in those places, yet is not working from there, it does not amount to a salary. So take a key of it. Any payment made to a person, not from the place where he's supposed to receive it from. And mostly in an amusement place or places of what? Enjoyment, does not amount to a salary. That chapter is closed for employment. Did I cover any other topic before we go through some problem numbers? I write something on sale of goods. Sale of goods, what you need to know is to differentiate what an agreement to sell is and what a sale is. Yeah, what an agreement to sell is and what a sale is. There are these two terminologies. A contract of sale and agreement to Section 2, subsection 1 defines what a contract of sale is. Section 2, subsection 4 defines what an agreement of sale is. All in all, a contract of sale occurs, yeah, reading now the definition, what is there? It occurs where a seller transfers or agreed to transfer property in goods to a buyer for a monetary consideration known as price. Where a seller transfers or agreed to transfer ownership in property or in goods for a consideration, ownership of property or goods to the buyer for a consideration known as price. So where, because those words, they are not there by mistake, where they say where a seller transfers or agrees to. So where it transfers, it becomes the first one, the contract of sale, where they transfer. And where they agree to transfer, it becomes an agreement to sale. Because there is the word agree to. In other words, there is no complete deal. So agreement sale occurs where there is a future condition to be met before a conclusion of the contract. Another key thing you need to know are what amounts to goods. We have almost 5 types of goods. Existing goods, future goods, perishable goods, non-existing goods, isn't it? Existing goods, these are the goods which are available by the time of entering into a contract of sale. Goods which are readily available by the time of entering into a contract of sale. Then non-existing goods are those goods which are not available at the time of entering into a contract. Perishable goods which can be damaged at any time. Yeah. What else? Once you appreciate those types of goods, you need to know the fundamental terms. The very terms in a contract happen here, a condition and warrant. The only difference is that you need to go ahead and understand implied terms of conditions and warrants. The implied terms now, every time they state, they pick one term, so you must be keen of these terms. They are like 5. One, implied term as to sell by sample. 2, implied term as sale by description. 3, implied term as sale by sample as well as description. 4, implied term as to fitness for purpose. And 5, implied term as to satisfactory quality. And the last, the implied term as to customs. Have you captured all of them? What is missing? Or where have you stopped? Implied term as sale by sample, that is 1. Implied term as sale by description, that is 2. Implied term as, now you combine the 2, sale by sample as well as sale by description. So it becomes the 3rd. Number 4, implied term as to fitness for purpose. And last, implied term as to satisfactory quality. Satisfactory quality. Then the last implied term as to customs. I want to give a custom. We have not mentioned what the applicable and sale of goods. It is known as Sale of Goods and Supply of Services Act. Sale of Goods and Supply of Services Act. So the only difference that I want you people to appreciate on those, because they may be one of them, is that they are saying the word implied means that they have not written, isn't it? They all have seen in employment. Implied terms like if they terminate you on what and what, that means you never wrote, but they don't recognize it. Here in sale of goods, implied terms we are meaning those terms which are not written, but must under the law be recognized. For example, implied term as sale by sample. We mean that when you're purchasing under a sample and you want more than one commodity, all the entire commodities must resemble. That's the only logic behind it. That you're buying in many, and therefore they must reflect what they showed you at the beginning. So if it is description, what do they mean? That you're purchasing by describing, and since they have appreciated your description, even if you want more than one commodity, they must comply with that. So in an exam, they only trigger by saying that this person purchased goods by sample. However, upon delivery, he found out that out of the 200 goods they had ordered for, 199 were complying with sample, but one was not complying. Is an happy and is before you seeking for an advice. What are you going to advise? Can he reject or he can retain? The law says you reject everything must comply with that sample. So even if it is 1 out of 200, you have the right of rejecting entirely because it is an implied term. Members, are we clear on those two terminologies? So the same approach to sale by sample as well as description. If you combine the two, you have described and they have showed you a sample you have appreciated. If you want more than one commodity, they must comply. Then fitness for purpose. The moment you go and make it clear to the seller the purpose to why you want that commodity, the seller must comply with that. Yeah. Now for that one, fitness for purpose, we mean you must make it clear the purpose to why you are purchasing that. Is it a party dress? Is it just for luxury? Is it any purpose that you will justify? The moment they give you something which cannot comply with that purpose, you can sue. That is a breach. Then customs, we are meaning it depends on where you have purchased it from. It is Techno. We know that purchasing from Techno companies or their agents, they must give you things which Techno can give. If you're buying from agents of Coca-Cola, we don't expect agents to put water, then the company brings soda only. That is a breach and you can sue under customs. We clear on that, members? Key word is that when you're buying more than one commodity, all of them must comply. You need to appreciate the rights and duties of the seller and the buyer before you go into a paper. Rights and duties of the seller and the buyer. What are some of those rights? Yes, if an buyer has ordered for delivery in installment, the buyer must deliver in what? Pardon? Where you order for delivery in installments as the buyer, the seller must deliver in. Those are the things they are requesting for. Packaging, if you purchase, who is supposed to package for you? So it is the duty of the seller to package goods and make them into a deliverable state. Those are the things they are requesting for under the duties and rights. In case out of the entire box of tomatoes, you find 10 which are perishable, can you reject the entire sack, entire box? They are from Kabale to Kampala. Only 10 are damaged because they are on the bottom. Can you reject? So it becomes the duty of the buyer to accept incidental damages that arise from a transit. Who is supposed to pay for the goods? So it becomes the duty of the buyer to pay for the purchased goods. In case the goods get lost, you bought a phone from M-Kopa, before paying it fully, you lose it. What can the other buyer who is the seller, M-Kopa, do for you? Can you recover the entire amount or damages? Yes? It's the duty of the buyer to recover the entire amount in case goods are in the hands of the buyer or having possession. So you need to be aware of those simple things. That's basically the sale of goods. Rights and duties of buyers, terms. Implied terms and express terms, as well as what creates the contract and also what amounts to goods. Yes, I've not talked about ownership. Who is the owner? When does title pass? Because in sale of goods, title pass with liability and title pass with the property. The moment you take ownership, you pay for goods that they give you, you become the actual owner there and then. So the moment you lose it, even when you have just taken it, it's your own liability. Now, what if you have purchased and you leave it in the hands of the seller? Then you find the seller has sold it. Is it in breach? Yes? You went, purchased a TV set at 1 million. Told him that since I'm going to work, I will pass by in the evening. In the evening, you pass by, he tells you that, no, I'm sorry. Remember, it was the only TV set remaining. With another one, maybe I sold both of them, and thereafter I will give you yours tomorrow. Can you sue that person?
Yeah.
Now, what if he tells you that indeed the person who has taken it is Mr. ABCD, your neighbor, the one you know, or your classmate? Can you go and recover it from that person?
Exactly, because the property has already been passed to me.
You can recover, or you cannot.
I can recover because I have my receipt as my property. So I will
recover because you're the actual owner.
Yes.
Yes. You have a receipt. It is showing its serial number. You know the where the TV is. And you can recover from that person. Even you can sue now the seller for a breach of a contract. Because he passed title and he again sold without the actual title. Yeah, so we need to know when does title pass. But basically, just know implied terms, they will state on those implied terms. Master implied terms, if you go ahead, read duties and rights. Any other? I'm not talking about company. I think most of you have appreciated what company is. I think that's the only topic I have not covered. Indeed, company and insolvency are the only topics. That's the talked about where. Do we all appreciate companies? Under companies, key things to know, they normally ask on promoters. Who are promoters? Yeah, a person who undertakes anything to form a company. If you read the definition under the case of Tycros versus Grant in your books, any person who takes any initiative or any step to ensure that the company comes into existence. It goes ahead with signing contracts, soliciting for people who will become members, submitting documents to the registrar, looking for fees, and so on. Any step to ensure that the company gets a certificate. That step done before a certificate are done by promoters. Exception is you don't qualify to be a promoter if you are of a particular profit, if you are an expert in a particular field where the company, what they are doing. If they come to inquire, for example, they want to start up a hospital, they go to one of the doctors, they seek advice. What are the things needed in the laboratory? What are the things needed before we register? That person speaks with an expert opinion. So that person seems to be a promoter. Get my point, members? If you're going to a lawyer who has studied what is needed to form a company, then he only tells you that no, the fees which is payable is this. Forms that you will sign are these forms. That lawyer can't be a promoter. Yes, he has done an activity. Even if he helps you to sign, he sees it because he's giving an expert opinion. So with promoters, they must be of a understanding, layman understanding of those aspects. However, you can be a lawyer, but the company wants to formulate this in, let's say, an accountancy firm. Do I need to be knowing what accountants do? So I can also become a promoter, simply because in that field, I'm not an expert. Yeah. Promoters are liable to every activity they do before incorporation. They are liable personally. If they are more than one, jointly, they are all liable. If they sign a contract and doesn't go through, or a company doesn't ratify, they are liable. I think that is captured. So the moment you find facts indicating that this company never adopted, just your mind should now go to know that these promoters are personally liable because the company never adopted. And the question could be, why didn't they adopt? They are the very people drafting the documents. Why didn't they put that provision? So if they fail, then let the liability be on them. That's the only logic behind it. Okay, leaving that aside, we all know effects of incorporating a company. Once you register, there's a difference between registering and incorporating. Incorporating means from zero, the company has come into existence. So you have submitted everything, they have accepted them. Registration means the company is already in existence. And maybe you're transferring it from position A to B. That's registration only. But incorporation does not been existing, you're just making it exist. Effects are that number one, a company gets a certificate of incorporation, it can sue or be sued, it can enter into its own contracts and so on. That's what they call perpetual succession. We all know what perpetual means. That you can leave or quit, but the company will remain. That is perpetual succession. In most cases, they may ask about duties of directors, duties of auditors, and also duties of secretaries. I think you need to list them. What are the key duties of directors? Duties of directors in a company? Yes, getting salary. To ensure that the company complies with the statutory requirements, e.g. filing of the annual returns. Only that, and they're the ones spearheading the meetings. Yes? And they're the one responsible for day-to-day managing of the company. Again, copy the duties of promoters, bring them to this side. That's how law is. Once you understand one concept, you copy and paste this side. Only, of course, you copy and paste with modification. Duties of secretaries, writing minutes, filing returns, calling for meetings. Only those. They register the company, registering members.
Chairs miss meeting in absence of director.
Now you're forgetting the key aspects. What if they bring aspects, a question rating that ABCD company has been in existence for the last 3 years. However, due to some circumstances, many people who advanced money to the company are demanding for the repayment. Mr. Zake one of the creditors has decided to sue ABCD company. Yeah. Then it tells you that Zach has obtained court documents that are supposed to be served on a company. Zach has presented the document to the secretary, who has declined and informed him that the directors are not present, and therefore he should wait for the directors. Zach is unhappy and seeks for your advice. What are you going to advise Zach? He got court documents supposed to be served the company. He found the secretary, he served him, he declined. And the secretary told him that it's not his duty, it's the duty of the directors. Therefore, he should wait for directors to call him. Zach is unhappy and is before you. What are you going to advise? Yes? Who is responsible for court proceeding? Auditor? Director? Secretary? Who is responsible under those three people?
The secretary.
Yes?
The secretary.
It's about guesswork. What? Let me see online students.
The secretary is the one responsible for court proceedings.
Okay, they are saying the secretary is the one responsible for court proceedings. So you need to master that when you're suing a company, then secretaries are responsible for everything in terms of court. They are the ones to hire the lawyers, they are the ones to everything. So one of the duties of secretaries is to represent the company in legal matters, countersigning documents, countersigning resolutions, giving out certified copies, filing returns, issuing notices, calling for a meeting, taking minutes in a meeting, mention but a few. Auditors, what are their roles? Roles of auditors. They don't have any role. What are the roles? To give financial reports. That's the word you even go and just add, audit, or give a financial statement. And when do they give it? At the end of the financial year or during the annual general meeting. Not the appointments, because they will ask you, they will now confuse you with the appointments. They will tell you that this director, this auditor has been serving as an auditor for the last 3 years. However, they want to appoint him as a director, or they want to appoint him as a secretary. Does that person qualify to be a secretary? Yes, an auditor who has served 3 years. An auditor who has served 3 years, can he qualify to be a secretary?
No.
Yes or no?
No.
Who qualifies to be a secretary? Pardon?
The one who is having satisfaction from the secretarial schools.
He qualifies.
Yeah.
People need to read those things. Qualification of those three people: secretaries, auditors, and directors. Secretaries, we are meaning you must be an advocate or a lawyer. Yeah, or you can be a member of a certified institution of what? Secretary what?
Studies.
Pardon?
Secretarial studies.
Secretarial
Secretarial
Studies.
Bureau.
Secretarial Bureau. I will just take over all the answers provided I've given you a guide. So you must be either a member of that institution, it's got certified secretarial institution or something, or it must be that institution itself. You are either a member, or it is an institution, or it is an advocate or a lawyer. Those are the people qualified to be secretary. And you must be, of course, if you're a human being, 18 and above. Directors, 18 and above, what else? Sound mind and what? Yes? Not prohibited by any law. Because once you make a company to go under bankruptcy, then you join this side, you are prohibited to become a director. So you're prohibited by that. You can't downfall the other company, then you come and take over a position to now downfall even this. You're prohibited. Auditors, you must be qualified. Yes, position of an auditor, qualification. Qualified what? A CPA or a member of ISPAC or an institution accredited by ISPAC. Those are the qualifications. Need to be very, very key. Lastly, voting. Who is the proxy? A person who can vote on behalf of a member. Rights of members in a company. Right to vote and so on. We have just mentioned them in the cooperative society. You twist and bring. Yeah. What is the share? Person who has a share, an interest, converted in a in what? Monetary value. Okay, liquidation, we have already talked about it under insolvency. Liquidation or insolvency in cooperative society, you copy, bring it inside, you delete the word cooperative society and substitute with company. Same liquidation process. Maybe we have not talked about the person who initiates it. Who is that person? A liquidator. And I think you must be knowing the powers of liquidators. Appointing other liquidators, making a report within 1 year. Liquidators can sell commodities by auctioning. They can pay all the creditors. Actually, the best way to understand the duties of liquidators, yeah, is to combine the duties of auditors, duties of secretaries, and duties of directors. Then you give them to a liquidator. That's the easiest way, the layman's understanding. Because the liquidator takes over all the positions of those people in a liquidation period of 1 year. So all the duties, if they were calling for a meeting, it becomes the one to call for a meeting under liquidation. If there are the minutes, they will sign and you will also sign. You will take those minutes. So he's now taking the role of the other. In case he sells and wants to make a true inventory or accountability, he still comes and make the duty of now the auditor. So you just copy all the duties of these 3 people, you give them to a liquidator. That being covered, members, I think it's high time. We can also, maybe what I never talked about in a company, there are simple things that you can check out. E.g., what? Lifting of a corporate veil. We all know what it means to lift a corporate veil. Knowing who are the people dealing with the company internally to make them personally liable if they're acting beyond their powers. Yeah. E.g., a director who doesn't have power assigned the contract. Instead of a company paying, that director can be held liable under lifting of a corporate veil. We have other things like individual management rule. Them I won't go into them but now. Okay, our debentures, I think you know what a debenture is. A document acknowledging indebtedness. Difference between a private company and a public, they are crucial. You need to be knowing them. e.g. one director in private company, how many directors in public? Two directors at least minimum. Members, one member in a private company, how many members are required in public? At least how many? At least? They can't be two. This now guesswork that since we have opted in partnership, we are going to invest in the company. 7 members. Yeah, qualified secretary in public company, whereas in private it is not compulsory. Qualified auditors or external auditors, whereas in this, not compulsory. Every public company must conduct an annual general meeting. In private companies, it is optional, or it can be carried out where there is a number, a good turnout. So those are the key things you need to be mastering. There's the prospectus. In which company? Prospectus in public company, whereas in private doesn't exist. What is the prospectus? A document issued out for advertisement or calling members to subscribe. Yeah. Okay. You said you don't want a break because I was going to give you a 10-minute break, but on agreement that any return is only for question approach, problem question, direct question, and the final question. And I think I would try like 30 minutes for that. But if you want a break, I can issue it for 10 minutes. If not, then we can proceed direct.
You can give you a short call ourselves.
Members, can I give you 10 minutes for refreshing? Our return is basically going, so I want now questions. Question past papers, then I give you a guide on how you can manage time, write effectively, and the answers we expect. Yes? No, I will return 30 minutes and release you. 30 minutes are enough for me to do one number, one paper, then we go. So please, 10 minutes are enough. All right, students, please confirm whether I can take your attention for the last minutes.
Yeah.
Okay. Because from here, tracing me could be another challenge. But still, you can make it the final. We have 3 sample papers. One was in August last sitting. One is on May last this very year. Another one I think is on this 2019. So basically, but which question did you want us to read through under the paper you have shared?
I wanted that one of number 2.
Okay, I think we can all see my shared screen. On incident, basically.
Yeah.
Says Kazmoto Limited recruited Kazinda as a plumber 5 years ago. He was a good plumber and all the employees appreciated his services. Due to financial distress, the directors decided to terminate some of the employees, including Kazinda. They were all given due notices of termination of their services. On expiry of the notices, they were served their termination letters asking them to leave the company. Kazinda was advised by his colleagues not to leave, but to sue the company. That is the first paragraph. Second paragraph, they say in another scenario, Maba and Bundula raised money and formed a company which was duly incorporated in 2016 and adopted Table A of the Companies Act, Companies Act 2012. The company directors were appointed and assumed office. Maba and Bundula, who promoted the company, approached the directors for a refund expense incurred on promotional activities. The directors are ready and willing to make the refund, but they have a feeling that payment of promoters of the company is against the law of Uganda. Second last, in another scenario, Balingo, a businessman in Mukula village, was approached by promoters of Bambo Limited, who requested him to supply them with bricks. The construction of the company's office broke. Balingo supplied the materials when he approached the company for payment a week after incorporation. The directors advised him not to demand for payments from them because he supplied the bricks before the company was incorporated. He is perturbed and determined to get paid for the supplies made. Lastly, Sulanta, who had supplied Bambo Limited with cement, was also demanding for payment. The directors made a resolution to ratify Sulanta's contract so as he could be paid for the cement supplied before the company was incorporated. Some shareholders are, however, contesting the decision, the director's decision required, raise the issues and resolve them. This is how we answer problem questions. The first thing to do, for example, if this is my blank page in an exam, you write your legal. We used to emphasize on brief facts, but students were overtaking time to duplicate the facts. Instead of summarizing in two words or three, find each is duplicating. So it is advisable, if you can't summarize, just be brief. Yeah? Indicate legal issues. You must put this in your exam. Nobody will write, exam now will not write it for you. It's of your benefit. Then you say 1, 2, yes, the heading legal issues is a must in B law. That is the formula. We don't expect something else. 4 and 5. Yeah. Don't raise more than 5 issues. You don't have time. Legal issues, all your issues must be numbered. Whether you're numbering them by 1, 2, 3, whether you start by A, B, C, we don't mind the way you have numbered them. Whether you use the Roman numerals, 1, 2, 3, 4, 5, it is okay. Whether you say A, B, C, D, E, is still okay. Whether you use 1, 2, 3. Our point is you must number them. I think that is also captured. Once you raise your issues, because you haven't raised them, the next step you will do is to tell us law applicable. As a heading also again, every number of problem question is out, it should be answered. Law applicable. Which law are you using? We have been talking topic, law applicable, topic, law applicable. So here is a number. You may find that paragraph A, okay, the first paragraph is in topic 1, second in topic 3, third in topic 8, isn't it? Order doesn't matter. Let's say the last paragraph 50 is in Companies Act. Yet the first paragraph is in partnership. And the second paragraph is about sale of goods. What we expect from you is still to number for us, and you just mention all the laws you think you will use. Not in order, but mention them. If it is only one, because it is possible that they can set entire number on one topic, tell us that topic only. Yeah, for example, in our law, what I read is that there is which act? Yes? Partnership. That's why I said if you don't know the number, don't put. Those who know will still add this word. But for you, if you don't know, please, is to be on the safe side, you just say Partnership Act. Yes, please. We are going to raise them. What's wrong with them? They are normally 4. In most cases, each paragraph gets an issue. 4. There are 4. Then the last one, you can say whether there are any remedies. Even if you give a remedy of 1 out of the 4 you raise it is okay. Yes. So law applicable, I've said you can say that. But if you think that the number has more than 1, then it is of good importance if you say number 2, you mention that. Yeah. E.g. Employment Act. E.g. Companies Act. So you can mention, if it is only 1, it is okay. Then if you just mention 1 for us, you are still okay, depending on what you have observed. Then some other lazy people who also want marks for free and who are wise, they add this one because it is also part of the law applicable. It may tell you Partnership Act case law. You can't mark him wrong because he's referring to some cases as forgotten. Yeah, you can't mark him wrong. So it is advisable that you put your law applicable. Then after this, the next step you're taking is you still put for us the heading. For us, we need to work on resolution of whether you say resolution of issues above, whether you say resolution of issues, it is okay. Once the word resolution, don't just start resolving anyhow. Tell us that you have started. Then you say, those who don't have time, this is now the importance issue. Are you getting a point? This person can even start from here and write. Issue 1, according to, he can write. Another person who may not, who has time, so he can now start bringing the other issues, reduplicating them. You recopy what you indicated at first and bring them here. Whether A, B, C, D. If you don't want, the reason why we say that you must number is to be sure that which issue are you resolving if you don't want to duplicate. Are we clear, members, on that online students? So you have a right of saying whether there was a contract, for example. Because we haven't raised any issue. So you resolve this one once you conclude issue 2, issue 3, like that. Issue 4. And you're done. Issue 5 maybe is there. Maximum 5, minimum 4. Those are the issues we expect. Maximum 5, minimum 4. The moment you resolve your issue 5, you go to the next number. How do we award marks? We come to these issues. Each issue takes 1 mark. So how many marks are here? What are you looking for this side? You're looking for 15. The worst is, under the 15, 4 times here we give it 3. If we don't give 5, we can give it 3. Then we give 2 on the law applicable. 2 marks. Still to make it 5. 5 are preliminaries, just showing us that these are the issues, this is the law you want to use. You already have your 5 marks. Then your resolution each takes 4 marks. Make it 16 at times to make it in that range. 15 or 16. That's how we award you to get 20. And it is possible for a student to get 20. The worst is that it is somehow funny for you to have the correct legal issue, you resolve it badly. You may resolve a good issue, you conclude badly. Yeah? Then there's a person who may raise a wrong issue, answers are correct. So we begin in somehow, some way. Let us raise these issues and we see how we can fit them in this paper. We are utilizing the time also. So the better is that once you're given a paper, there and then read all entire paper and master what it needs. If possible, you can even underline. Because once you read this paragraph, you can know where the issue is. Isn't it? For example, if I am to repeat and we get the issue for our first paragraph, Kazimoto Limited recruited Kazinda as a plumber 5 years ago. He was a good plumber, and all the employees appreciated his services. Is there a problem? Remember, we call this problem question. So you must look for where the problem is. Man got a contract, he has worked, he was appreciated. We don't have a challenge in that perspective. Yeah, they are saying that due to financial distress, the directors decided to terminate some of the employees. Is there a problem? Yes or no? They are terminating people now. Is there a problem? How are they terminating them? Yeah, terminating is the problem. But now how are they terminating could be another aspect that can contribute to that. They are telling you that including Kazinda, they were all given a due notice of termination of their services. Is that a problem? On expiry of those notices, they were all served with termination letters asking them to leave the company. Is that a problem? They have given you a notice, a sufficient notice. It has expired, they have handed over a termination letter. So here comes now Kazinda, whom they are saying that Kazinda was advised by his colleagues not to leave, but to sue the company. Is there a problem? The problem is on that paragraph. He was served the notice ended, they gave him a letter. His colleague is now advising him that don't go, take them to courts of law. That's why the problem is. So what is the best issue we can raise? And most of the issues, you get them from the last sentence to know your client, your customer. Whom are you advising? So Kazinda is your customer. So advise Kazinda. First raise this issue. Because in court, you don't come and just give a speech. It's not a speech day. You raise an issue, then we see which issue you're raising, whether it has some fresh to back up. So which issue can be raised on this? Whether. And all issues start with the word whether. Why? It is a two dimension. You're either going to confirm a position or you go against a position. And in law, we can mark negative positions. Whether there was the contract and you're concluding saying that there was no contract. So that negative answer gives you marks. But you must defend it. So what is the issue?
Whether Kazimba's termination was lawful.
Whether
Kazimba's termination was lawful.
whether Kazinda can succeed in suing. Yes, let me write. I've not heard it well, but it is a good issue. Whether
Kazimba's termination was lawful.
okay, let me first write the issues you're giving me. Whether Kazinda's termination, yes. I don't know a student who is giving me an answer.
Whether Kazinda's intention to sue the company was justifiable.
Okay, you have changed the direction. Okay. I add this one. Whether Kazinda's intention to sue, you can wait right because we are just giving 8 until we justify 1. Yeah. I want to see the dimensions and I get it accordingly. Whether Kazinda's intention to sue the company was justifiable. Is justifiable. You can't say to sue and now you say was. You're now in the past. Tense matters. Is justifiable. Mister, you had proposed some issue. Whether Kazinda can succeed. Then, sorry. whether Kazinda can succeed in suing Azimoto Limited, yeah? But they say not upon his termination. They say the termination ended. So even if you stop from here. Any other? They're the one which I've seen in the comment. That whether Kazinda can. Whether termination of Kazinda was lawful. Any other? Under this, there is the most correct issue that at least we need to adopt. What is that issue?
Issue 2.
Yes?
2.
2.
Yeah, whether Kazinda can succeed in suing Kazimoto Limited.
Actually, these two, this and this, all can get marks, which are required on raising. But this one automatically goes off. Whether termination of Kazinda is lawful. Are you challenging its termination yet? They have told you that the period expired. Are you challenging that? Yes?
Termination was lawful already.
It is already lawful, so you're not changing anything. So the third one doesn't suffice. So these two, it is a matter of English, but they mean the same. So what is the correct answer there? Can this Kazinda succeed or not? They were all the employees were served with notices. When the notices became due, they served them with termination. Becoming due means that each took its period. They now serve them with termination. A colleague is advising Kazinda to sue. Can he succeed?
Cannot.
So can now build it. What do we need to add? How can you resolve now? Yes? First of all, where does it fall? So it falls under employment. Okay, so issue number one, whether Kazinda can sue, whether Kazinda can succeed in suing Kazimoto, is it? Sorry. Kazimoto Limited. Is this how the issue was? And succeed in, yeah, okay, yeah. What do we need to add from there? We have known that. Can he succeed? We have agreed that he cannot. Why? Yes, what is the reason why he cannot succeed? They follow the legal procedures of termination as provided for under the Employment Act. Okay, so how could you resolve now officially to get your 4 marks? You only have 2 marks. One of citing us a good law and also citing for us a good issue. According to yes. Yes. And an employee should be given a notice before termination. By Kazimoto. Therefore, pardon? No, he hasn't sued. They are telling me that he wants to. That's why even our issue is that whether he can succeed in suing. So he hasn't sued. He's seeking whether he can succeed. So you still conclude confirming the position. So which position are we confirming?
Therefore, Kazinda
Therefore,
cannot succeed. Kazinda cannot succeed in suing Kazimoto.
Cannot succeed in suing Kazimoto. You get it. You have everything there. You have shown that one of termination is by notice. The company gave sufficient notice. So, what is this person going to do? Under no full termination, yet there is one of the modes is termination. But this one comes when a person knows that one of terminating the contract is by notice. And you have now indicated that since they have employed one of the modes, then this person cannot succeed. This is the full resolution of this answer to get your 5 marks. If they can fit in 4 lines in my poor handwriting, then you're good handwriting.
Excuse me, sir.
Yes, please.
What's the period for issuing that notice?
No, they have not told you the period because after all, they have told you that all the word due. What does due mean? Now goes to the English. Due. If I say that your payment due is today, what does it mean? Is ready. Yes? What does this statement mean? Because it's very clearly stated. They were served their termination letters asking them to leave. No. There's a word due somewhere. Due notice of termination. Where is it? Yeah, the first paragraph. They were all given due notices. Can that answer the period? That whether you had worked for 10 years, your due notice was given. Like your sufficient notice was given. Whether you worked for 60 months, so they are generalizing that it was given insufficient time. So here we can't say that whether the period was followed for 3 months. No. The word is due notice. Yeah, so this is a complete issue. This person cannot sue and succeed because he was given a due notice. They only wanted to hear the word notice, then concluding that he cannot sue. Issue 2, whether, yes, those are the facts. In another scenario, Maba and what is that name? Wundura raised the money and formed the company, which was duly incorporated in 2016. And adopted, if you're answering, your most important part is now to underline the word adopted table. What comes in the mind when a company adopts table A? Now you just switch that promoters will be automatically paid. That's the next thing. Then you now read the other things following. Because you have known that it's adopted, and adopting means that promoters must be paid. So they are saying that it adopted table A, the company directors were appointed and assumed office, Maba and Udula, who promoted the company. Even they are now bringing the element of promoted, so they were promoters. Approached the directors of the company for the refund expenses incurred during promotional activities. The directors are ready and willing to make refund, but they have a feeling that payment of promoters is against the law. Is it true that it's against the law? Yes
No.
or no?
No.
No.
Not by this statement. Generally, are promoters supposed to be paid?
They are supposed
Yes
to
or
be
no?
paid. They are supposed
They
to
are
be
not
paid.
supposed they are not supposed to be paid unless they adopt table A.
You know, it is simple. Promoters don't have automatic right of payment. So the exceptional rights are where the company can adopt, then they can pay them. That's why these people have a feeling that promoters are not supposed to be paid. But then they have forgotten that they adopted table A. So which issue can you raise? Whether? Yes? Whether? Which issue can you raise? Whether the directors can pay Maba and Budura for their promotional expenses or activities. That's issue number one. Or you can say whether Maba and Budura are entitled to payment as promoters. Then in resolution, you're resolving indicating that from the fact where the company adopted table A, it gives a right to a promoter to be paid. Therefore, since the directors are willing to pay and the company adopted table A, Maba and Budula are entitled to payment. That's right, it may be for clarity purposes. That's how we raise. Issue two, whether Mabu and forgotten the parties. Mumbuba. Madura. You put the names. Those are the ones entitled to. Are entitled to payment. Payment as promoters. Do we have that law applicable here? Yes. We have it. Then here you're saying that because you have read your issue now, issue two. Yeah? According to what now? Companies Act. Once a company adopts which table? Table A, promoters get automatic right of payment, job remuneration. From the facts, since the company adopted table A, directors and pay, then you mention them, Maba and Avula were there. Promotional expenses. How many? Imagine just writing this. You go the next number. The last, second to last. Yet in another scenario, Malingo, a businessman in Mukula village, was approached by promoters of Bambo Limited who request to supply them with bricks for the construction of the company's office block. Balingo supplied materials. He was approached by who? Promoters. So you now put it into account. And remember now this is a different company. It's not the same as the other one. Okay. So he was approached by promoters who requested them to supply them with materials for construction of the company office block. Balingo supplied materials when he approached the company for payment a week after. Does that make sense now? A week? Two things you need to consider when you're doing this company-related aspect. Prior and after. If they say prior, they mean at what stage? Yes, prior. Before. So you know that before incorporation, you know the effect. Then after incorporation, you should be knowing the effect. So they are telling you that a week after the incorporation, the directors advised them not to demand for payment from them because they supplied bricks before the company was incorporated. Isn't it true that they supplied after the company was incorporated? He perturbed and determined to get payment. He is perturbed. Who is perturbed? This promoter, Balingo. The businessman, and determined to be paid for the supply he made. Can he be paid? Yes or no? By whom?
He can be paid by promoters, not the company.
Yes?
I said he can demand payment from the promoters and not the company.
One is saying that he can demand payment from the promoters but not the company. Is that true? Yes or no?
Yes, because the company has not adopted the contract in the statement.
Because why I'm saying so, because the company had not ratified the
So there are two
activities
things.
that happened.
You're saying now the two
Operation.
aspects you're bringing. One says the company has not adopted, one says the company has not ratified. They are all correct. Because ratifying is like confirming what was earlier mentioned. Adopting table A automatically is under the act supposed to be done. Table A is basically for public companies. Yeah? And promoters in public companies are paid. So that's why we say that once the company adopts provisions of table A, then also the promoters should be paid this side in private. That's the only logic behind it. But ratification can be done at any stage, even if a company never adopted table A. So it is a remedy number 2. The last remedy is when it is provided for in the articles. Those are the 3 remedies where promoters can be paid. Adoption of table A, ratification, and provisions of the articles and association. Yes, please. You are looking at the period where you went to request for a payment, but from who? You can only recover from promoters directly, not company. Get the point? So this issue basically, since there is no ratification, there is no adopting of Table A, there are no provisions indicating that the promoters are supposed to be paid. Then, yeah, those two, you can recover from promoters, not a company. We get the point, members, on this. So it is the opposite of the other one. That there was ratification here, they are telling you that no, there's nothing like ratification. And the man wants payment, he can recover from promoters. Lastly, they are even bringing the word ratification. Entire number rotating on promoters. Solanta, who had paid Bambo Limited with cement, was demanding for payment. The directors made a resolution to ratify Solanta's contract so that he could be paid for the cement supplied before the company was incorporated. Some shareholders are contesting. Some shareholders, however, contesting the director's decision. Yes? Since they ratified, they made a resolution and ratified. Can this person be paid from the company?
Yeah.
Because of the word ratification. So just appreciating what adoption means, adoption of Table A and ratification, makes it automatic that this person can be paid. Are we seeing our number rotated on promoters only? Yes, please. And resolve this there and then. Goes to issue number 2. Can be marked, but then that is, doesn't make a good uniform work, but can be marked. Because also the major point is that we are looking for issue, role applicable, and resolution. So we can also mark you in that perspective. That is issue 5. Issue 5, your issue number 5 should be whether what? Any remedies available. Do we have any remedies? You generalize. You don't say that under paragraph 2 or issue 2, this is the remedy. No, just state. For example, under the first issue where we said Kazimoto cannot sue, is there any remedy there we are going to give? Which remedy?
No remedy.
But then they are telling you that you wanted to sue, you never sued. So is there a remedy? There's no remedy. So you find that the entire number has no remedy, that paragraph. Then on this second one, where the company adopted the Table A, what is the remedy? Who is now entitled to payment? So you're now saying that the promoters, you mentioned them, yeah? Brackets, Mabu, Bamaba, and who? Abdullah are entitled to payments. From who? A company, Kazimoto Limited. So this becomes the remedy. Even if you give one remedy, it's okay. About remedies. Yes. But then, if you don't want to put it and remain with 4, where you conclude, for example, where we said Therefore, since the company adopted table A, directors can pay this and this for their promotion expenses. You have even given a remedy. You can still get your mark because you have concluded with the remedy that they can pay. Only here you may re-emphasize or leave. Let us go some other, maybe a simple number and with number 3.
Excuse me, sir.
Yes, please.
Yeah, now when you said that when we are doing this paper, you have to start with the issue, law applicable.
Yes, law applicable, resolution.
Yes, then here I'm seeing that in this number 2, last 3 paragraphs, they only have one law applicable. So do you write it once or you can still
So you
repeat
write
the
it once, you don't duplicate. Once is one, you write only once.
Thank you.
Yeah, that's why even I say that even if this entire number having only one law applicable, just say Companies Act and keep quiet. Then you go the resolution immediately. You don't duplicate. Yeah. Issue number 3, let us see what they needed basically. Root a banking officer and backer, an international auditor with CU Bank, met Biondo, a prominent businessman in Chikubo, who suggested to them that the partner start exporting onions, marijuana, Indian hemp, red pepper to Kenya. He assured them that the business was very lucrative.
Lucrative.
What do they need there? What is the problem? Marijuana is the problem. The problem can't be marijuana. Whether the objects they are using are lawful. Whether they are dealing with illegal objects. Which law is there now applicable? Yes? Sale of goods and
Sale of goods.
partnership. Which partnership is coming up from where now? Simply because they have told you that they want to partner and make a business. It should be contracts, whether they can. But even if you go for partnership under Section 10, business done in common for lawful objects. Yeah, business done in common and with the name of making profits. But is this business lawful? So you can say whether they can patent for whether root, backer, and there are only 2. There are 3. Root, backer, and Biondo can operate a business of that nature. Yeah, whether they can start up that business. Then from your resolution indicate that according to either Contracts Act or you can say according to the Partnership Act, since they want to partner together, any business done must be having lawful objects. From the facts, which one is not lawful? Marijuana is not lawful. So you say from the fact, since they want to deal in marijuana, which is prohibited in Uganda, it renders the entire contract unlawful. Actually, it is about contracts, not even partnership. It's about a contract. You want to supply them. Yeah, they want a prominent man in Chikubo who suggests for them that they partner to start exporting. It's a business. They want to do a business. But it's a business in common for a contract. So your problem here is to say that that marijuana is a prohibited. Is it allowed in Uganda?
No.
The moment they substitute marijuana and they put opium, you people, you will now say that opium is lawful. That's how students are. You teach them A, you set B, they tell you that B is now better than A. Okay, on realizing that they needed capital, each one of them was tasked to invite 6 reliable friends. How many are they? Each one, they have invited now 6 reliable honest friends to join them. Ruth, Baker, and Bayondo, together with 18 others, proceeded to do their business. Is there a problem?
Yes.
Which problem?
Whether
the business they are operating, whether the business they are operating in imparting is lawful, or the business they are operating together is lawful. Then you guide and define now which one. What are you going to define? A partnership.
Their number is
That a
exceeded.
partnership is a business done in common between two, not exceeding 20, for a lawful, for an intention of making profits. A business done in common between two, but not exceeding 20 members. Then you say from the fact, since they were 3 and it is supposed to bring 6, it makes a number to go to 20, exceeding the advisable number of, it makes a number to be 21, exceeding the advisable number of 20. Therefore, their business is unlawful. Just is a systematic number. Yes? Let me see. In another scenario, Timber Limited deals in timber and furniture. The company board of directors agreed to hold the annual general meeting, and the managing director issued a notice for annual general meeting to be held in 1 week's time. For how long should be the annual general meeting? 14 or 21? 21 days. So here they are giving you how many days? That is even enough for you to know what they want in the next. Yes, please. Yes, the shorter notice where the issue is urgent. That's why you call for extraordinary. A shorter notice. Then you must give a justifiable reason why you're calling for that. It is allowed, but you give a reason, genuine reason. So let us see whether they gave a genuine reason. And the AGM was scheduled was held as scheduled, but some members were absent. Are they giving a reason why they gave a short notice?
No.
No. Okay. Some members were absent because they were attending their political party's delegation conference. When all matters deliberated upon were brought to the notice of all members, including those who never attended, the members were of the view that whatever took place could not be relied upon. Whether it is lawful to rely upon what was, whether it is lawful to consider what was approved in the annual general meeting. Then your issue should be, since the annual general meeting never followed the stipulated time frame of 21 days, everything that was done was illegal. Therefore, members cannot follow what was followed in. Members cannot follow what was resolved in. I think that element. Failure to comply with the time frame of the notices for annual general meeting makes everything they discuss to be illegal because of lack of what? Quorum. Yet in another scenario, Armstrong Public Limited. So they are now telling, is this a public or a private company? Yes or no? Armstrong. They are now making it clear. If they want to show you that it's a private, they just leave the word private. If it is a public, they put. Another scenario, Armstrong Public Limited was purposely reformed to save money for home, and most householders became members. There were several directors of the company, which was incorporated on 30th October 2016. The annual general meeting was held on 7th of May 2017. What is the problem? Time of what? Whether the meeting which was held, whether the general meeting which was held on the 7th day of May 2017 was lawful. Whether the meeting which was held on 7th day of May 2017 was it lawful? Why? The law says the end of the financial or calendar year. Actually, the word is calendar year. End of calendar year. So the company which was incorporated on 30th of October, its year will end which year? And which date? 30th of October 20. So holding it in May means that even it had not reached the maximum period of holding an annual general meeting. So you're saying that even whatever was indicated in that meeting were unlawful since the end of the year, where the annual general meeting should be conducted, was not, the time frame was not followed. So here you begin with the date. The company, you can't form it in October, then the annual general meeting, you hold it in May. You still need to wait for October or past October. Isn't it? Lastly, however, some members had many issues to discuss and requested the directors to convene another meeting. The directors decided to convene another meeting in December 2018. But members were still not happy about the directors. What did we say about the difference between a private and a public company in terms of annual general meetings? In private, it's not mandatory, but in public. So these people exceeded the period. It was mandatory for them to hold it in October, but not in 2018. Therefore, it was a breach of their duties as directors. Do we say how we resolve this? This sample question, I think I will end from that. Let me see what were the direct questions. Explain the difference under which an offer can be terminated. Didn't we discuss this? Difference between duress and undue influence. Didn't we discuss? Grounds upon which undue influence can be restricted. Didn't we? Where you can lift undue influence, where it cannot apply. Once you appreciate what undue influence, then you can know when it cannot apply. Yeah, if you are willing, you can't say that you are forced or you are exerted under pressure. Or if you're past the time, reasonable time. Then describe sources of fraud. Didn't we begin with this? Duties and liabilities of trustees. Didn't we discuss this? Let us see another sample paper, but not in details, just what they normally ask. Where? I think this. Because I see we are out of time, but just knowing what these people normally say. Downloads. Okay. Let us see the last question. First of all, what they intended to do. This was August this year. A bill payable to the bearer, bill payable to an order, a bill of payable to on demand, then on a future time. Did we discuss this in banking? Payable on demand, we are meaning a demand, I mean a check. Payable at a future time, we are meaning promissory note. Payable on order, we are meaning court order like Maleva injunctions or garnish. Payable to the bearer, a person who is in possession of a bill of exchange. Different duties of an agent towards the principal, we discussed these duties. Accountability and so on. And I said you can copy and paste from others. Sources, different remedies the party can get in breach of a contract. Remedies we gave them when we were discussing mandamus and so on. Restriction, compensation at the beginning. Yeah. Sources, I mean different classification of, I remember telling you private law vis-a-vis public. So these things repeat. Your side, they will set for you a hierarchy of courts, I'm very sure. But then it doesn't exonerate you from. Then let me show you an example of a question on cooperative societies, where they have been stating it. That's paragraph. Another scenario involved local cooperative societies, Loketo, which has been going through financial difficulties. Its executive director has given notice of meeting to pass a resolution for amalgamation of Loketo and Abla Cooperative Society. The objective for amalgamation was to take one big financial stable society, whereas Abla was yet to hold its annual general meeting. Loketo held its general meeting, where members objected to passing a resolution for amalgamation of Abla. The members' objection frustrated the society's executive committee, who can determine whether other people can join or not. Isn't it in the annual general meeting? Isn't it by members? Because anything affecting the nature of the society or even a company, it is decided by members. Directors can only decide on matters which can, the administrative matters, but not everything which affect entirely. So these people, were they lawful to object? Yes or no? They were lawful because they are the one to decide, not the executive committee. What else was big there? Maybe, yeah, what wants to be advised. Another number is on check, if I'm seeing. That B, what has successfully paid, is it a check? Successfully applied for a salary loan to buy a car, is it sale of goods? What has successfully applied for a salary loan to buy a car from Hinda Motors? The car cost shilling 30 million and she made installment of 15 million, expecting to top up the balance in 3 months. Ota issued a check of 15 million for the payment of the installment, and the agreement for the purchase was signed. However, the check which she had issued was dishonored, and after getting information to that effect, Ota offered to pay the money in 2 weeks' time. Hinda Motors later seized the car and sold it. Ota wants to be advised about the possibility of suing Hinda Motors. Can he sue Hinda Motors? Yes or no? Why? I'm seeing yes or no answers.
No.
Can he sue Hinda Motors? He issued a check, it bounced.
He can
Yeah?
sue.
He can sue, he cannot. Then he's requesting for an offer that he pays in 2 weeks. These people have rejected. Was there a sale or there was an agreement sale?
There was agreement to sell.
So can he sue based on an agreement sale?
He cannot because the property hasn't been passed on him.
And an agreement sale, when does the property pass? Yes?
Sorry?
When you have fully completed.
Yes.
When property can pass. So in this scenario, can he sue Hinda Motors?
He cannot.
Because order is before you, thinking on a possibility of suing, whether he can sue or not. He wants to know whether he has any right of suing. Can he sue? Yes? Who was the true owner of this what? Car?
The car is still in the hand of Hinda Motors.
So his own Otta was having what? In that regard?
The logbook.
Not logbook. Otta can't have a logbook and is not the owner. He's having possession, a mere possession. If we give you a phone from Mkopa, then you're only having possession, we are having the title. Not until you make a full payment. Don't we have a right of requesting it back in case of failure? So can he sue them? Otta doesn't have a right of suing because it was a mere agreement to sell, not a complete sale. And he failed to pay as required. Whether he paid, but it was dishonored, the other people never received the money, so he cannot sue. But he can make a top up, they give him another vehicle. That is the only remedy. He cannot sue. Yeah, so you need to be keen with sale of goods. In a different scenario, Puno's brother, Konye, entered into a contract of employment with APT Limited for 3 years. After he had worked for 3 years and after the expiration of the contract, Konye continued working and receiving salary. A year after expiration of the contract, Konye was issued an identification card, whose expiry would be after 2 years. However, a year after being issued with the card, he was given a notice informing him about a non-renewal of his employment contract. Konye is very confused about the validity of his employment. Does he have a valid contract of employment? His contract expired when the 3 years also elapsed. So he has been on mass of God. So you're only advising that whether Konye has a valid employment contract. Then say from the first, since I signed the contract of 3 years and expired, he doesn't have any other remedy. Yeah, he's no longer an employee by virtue of expiration.
Excuse me, sir.
However, we all need to know that, yeah, I think that one is for that because the other one applies to where you have worked for 6 months. Then they don't renew your contract, but they retain you. Yes, please.
What of that part where they are saying they issued him with a national ID for 2 years? Isn't that implied?
An implied contract.
Yes.
Yeah, after a year after expiration of contract, Konye was issued an identity card whose expiry would be after 2 years. However, a year after being issued with the card, he was given a notice informing him about a non-renewal. They give you a notice, yes, of your non-renewal of employment. Do you still go ahead and sue them? They issued you a card, but they are even telling you that we are no longer interested and therefore want to terminate. You cease. So it doesn't have any valid reason of suing them. Okay, those were some of the sample. Maybe the last could let me check on this paper. I won't read, only that see what was there. I think this is the last. See the last part of it. Okay. Number 5, describe various duties of a bill of exchange holder. Bill of exchange holder duties. If you're the one in with a check, what are your duties? You're holding a check. You're having possession of the check. You can remit it within reasonable time and ensure that all those duties Discuss different types of agents. Haven't we discussed this? Auctioneers, lawyers, patent, yeah, and so on. Explain the valid elements of a contract. Didn't we discuss section 10 and we highlighted those key elements? Explain different sources of? No. Every number I beg and I can request in an exam, if possible, all of you do number 5 and 6. They are direct numbers and you can mark yourself. By virtue of telling you that different types of agents and you know 5, you know that 5, when I bring 1 and explain, those are 2 marks. So out of 5, I have my 10. You are assured. Yet in a problem question, you can't be assured. You raise the wrong issue, solve it right, we fail to give you marks. Yeah? Then maybe let me see what could be more clear. Let me see whether you read like question number 4, first paragraph. Gen 19, Gen 17 are sisters and former students of Gifted Hand, SSS. Their former school established a cooperative society called Gifted Hands Cooperative Society, which runs an agricultural business in their home district and gives loan to former students at a low cost rate. They wanted to join Gifted Hands Cooperative Society, so they approached its current leader and asked if they could join, and he laughed at them and told them that they are still young and they cannot be eligible to join. I mean, he told them that they are eligible to join after 10 years. And this has caused them great frustration. Advise them. What are they looking for? Yes? Where is the problem?
Whether they were eligible. Like
Whether they are eligible to become members. They are looking at the membership. And basically, number 1, we said that you must come from the same location or area. And there is the former students, then the society for former students, so location is okay. Now second, the age.
the age.
One has 18, doesn't that one automatically qualify? Then that is passed on section 5. Then section 13, it requests for a person who is below to be of which age?
12 and
12.
above.
Even the one of 17, isn't it? Way above 12. Can they all qualify? You're going to, just in case that whether they are eligible to qualify, then you say under cooperative society, for one to qualify, it must be from the same area or same jurisdiction, as well as having the age. From the facts, since they are all former school students of CS, Gifted Hands Cooperative Society, by jurisdiction they qualify. And mostly, since one is 18 and above, any member who is 18 qualifies. However, exception is if you're above 12 years, you can also qualify. Then you also bring that element that Jane can also qualify since he's above 12, being that he's 10 years. Simple as that. So they were looking at membership. Yeah. The second one is about sale of goods, if you're very keen. That's how they said. Dean Jane Mothers, Dana has been running a suit boutique at the local market for over 15 years. 7 years ago, she signed a contract with a supplier from Turkey, and it stated that she would pay for the goods after they had been successfully delivered to her shop by the supplier. Recently, Dana ordered 200 suits for ladies, and they were successfully shipped into the country by the supplier. However, the truck that was transporting them to her got involved in a car accident before reaching the shop, and all the suits were burnt to ashes. The supplier demands Dana to pay for the suits because they had already been shipped from the country, but Dana refused to pay. Advise her. What do they need? That was the point I said that this one, even if it comes in which way, you must be in an angle of knowing. What do they need? What is the problem there?
Passing of the title.
Pardon? Which factor can you, is this rate liable to pay? It is not liable. Under what circumstance? Frustration.
There is that.
They only need the word
There is
frustration. And sudden happening. Accident is part of them, floods are part of them, war outbreak, fire, and so on. So they only needed you to say, since she has not received the suit due to an accident, which is a frustration, she's not liable to pay. Frustration just. Members, let us really go and embrace these things. It is past time. I don't think there's anything I can add at this moment. Yeah, I don't think there's anything big. The only way I can say is that be free to chat with me, whoever is willing at any time. Yeah, whether on WhatsApp, email, any challenge on a question paper, I'm there to guide you from now until you do your final exam. Those are only 2 weeks from now. But you can turn everything and you make it right. These are things which are, just go through the last 3 papers. You will just see the trend. Cooperative society, sale of goods, banking, contract, and company. That's what they are setting. Yeah. So that is it, members, from my side, and for the guidance, endeavor to do your last 2 numbers, 5 and 6. Those are free marks. In your objective, you can also know that these objectives have obtained this and this. So you even assured that out of 40 numbers, because each number is 20. The other side, you have failed 10, you know you have 30. Objectives, you have also failed 10, you know you have 10. Those are 40. A problem question, you're supposed to do 2. So already assured that out of the 2, I can't fail to get 10. But the moment you go for all the 3 problem questions, you'll be disappointed. Yeah, otherwise, really, I wish you the best. I thank you for turning up. I think we have summarized all the topics. Yeah, but then you can read. Below is the easiest. I rarely meet students and they fail. It is rare. Very, very rare. So I don't want that you become the pioneers of the regime. Current online students, please log out. Physical,